हेलो। 2:30.
What is the urgency?
Sale is scheduled on 15th. And
Huh?
Sandhya Prabhu advocate has moved the matter and it
On
was
15th.
15th. And, we have already, Sandhya Prabhu has moved the matter. That it was, the file is in the bench.
Why do you move at the last minute?
No, she moved it.
No, I'm saying, why do you move it one on the day,
No.
1 or 2 days before the sale? How
She-
many days? The sale notice is long back.
But she moved it. Right?
When did you move it? Why
She
do you
told
come
me,
with the-
she
huh?
told me that she has moved.
No, that
and
may
it is
be
in-
so, but what I'm saying is, why do you wait till the date of sale tomorrow and then move the memo? Now the day, the public auction is fixed long back, isn't it?
Please,
Now
madam,
then why
but
you don't move?
she told me that she is
Put it,
taking
put it.
attempts and 2:30.
KVT
Please.
ಇದ್ರೆ ನೋಡಿ.
Please. Illa KVT.
Let's. Serial number 13,
Just wait.
please.
Page number 1, serial number 1 to 6, page number 2, 7 to 16,
It's serial number 13.
13.
Advocate on record is not feeling well.
Respondent in this matter, my lords.
Ah.
This is the third adjournment for the same reasons. In the last rate of last occasion, interim order was vacated.
Last occasion, interim order was vacated. There is no interim order. As per the instruction, my lord, advocate on record is not feeling well. I am the Fraxy counsel, I make a submission. 15 may be given, I will read it.
Monday.
Please,
Monday.
please.
15.
At request, release the matter on Monday.
Page number 3, 17 to 21. Page number 5, 24.
23, Your Honor, serial number 23, I filed a memo for the withdrawal. Kindly 180. Yes, file action. Serial number 23.
Idli. We'll pass orders. Idli, ಬಂದಾಗ ಹೇಳ್ತೀನಿ. We'll pass orders.
Page number 5, 24. Page number 8, 25 to 28. Page number 9, 29 to 33. Page number 10, 34 to 37.
Before your lordships, I appear for the petitioner in this matter. An impleading application has been filed for which I have to file objections. It may be taken up on 22nd, your lordships.
We are for impleading the applicants.
Lord
I
Mayor,
wrote a copy last week.
Inform the other side.
They're impleading.
Others.
State, your lordships.
Mahesh
Lord.
Kiran,
One council has filed wakalat, your lordships.
Mahesh Kiran.
I'll inform you.
Yes.
Lord, this issue is already covered, my lord. It may be taken 15 and disposed of. There is no, nothing is left to hear this matter because quorum consists of the what in the bylaw says. So there is already covered. My lord has passed 2 judgment over on that.
It may be taken up on 18th, your lordships.
Monday we'll have it.
Wednesday, your lordships.
Release the matter in the same stage. On
18, Wednesday holiday.
18.
18th.
Page number 11, 37.
Serial number 38, my lord.
Page number 13, 38 to 41.
Serial number 38, my lord. Kindly press for 2 weeks' time.
Have you informed the other side?
My lord, I appear for the petitioner in serial number 13.
At request. Release the matter week after next.
Serial number 40, Your Honor.
Yes.
The petition is seeking mandamus by directing the respondent number 4 to announce the result. But one more matter, the Honorable Court granted stay from announcing the result. The matter on 15th, Your Honor, it may be posted on 16th or 18th.
No, the other matter is on 15th.
15th, Your Honor.
We'll have this on the
ಇಲ್ಲ
same.
ಅದು 2:30ಗೆ ಬರುತ್ತೆ ಮೇಡಮ್ ಅನಂತರ ತೆಗಡಿ ಸಹಾಯ ಬರೋದು 2:30ಗೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ದಟ್ ಇಸ್ ದ ರೀಸನ್
Review.
16th or 18th it may be
Release the matter on 18th.
18th.
much obliged.
Page number 14, 42 to 44. 15, 45 to 48. List 1, fresh matter, serial number 1, Amaresh N.
But in this case, I appear for the petitioner. The petitioners here in Malad challenging the order passed by the returning officer at Annexure A, passed on 28/3/2024. Malad by adjourning the same for what of quorum. Malad and the out of 11 directors, the two persons, that is petition number 1 and petition number 2, filed the nominations for the post of president and vice president. And my lord, the two persons only filed the nominations. No one others yaro file madila nominations.
Quorum is there.
Quorum is there, my lord.
La-
On that day, my lord, kindly,
What is the quorum as per the bylaw?
my lord, there are five members are present.
No. What is the quorum as per the bylaw?
6,
6.
please, my lord.
So now, how many were present that day?
5 members.
And then,
My lord, on that day, my lord, out of 11 members are present. When the meetings are proceedings are going on 28/3,
where do you get that?
Annexure A. In page number 17 and 18. Nirdeshakara Paiki, that is in second line, my lord, that is the typed copy. ನಿರ್ದೇಶಕರ ಪೈಕಿ ಕೇವಲ 5 ಜನ ನಿರ್ದೇಶಕರು ಮಾತ್ರ ಸಹಿ ಹಾಕಿದ್ದು. 6 ಜನ ನಿರ್ದೇಶಕರುಗಳು ಗೈರು
You're
ಹಾಜರಾಗಿರುತ್ತಾರೆ.
reading at page?
18. Typed copy of the annexure A.
ನಿರ್ದೇಶಕರ ಪೈಕಿ ಕೇವಲ
5 ಜನ ನಿರ್ದೇಶಕರುಗಳು ಮಾತ್ರ ಸಹಿ ಹಾಕಿದ್ದು.
ಹಾ.
6 ಜನ ನಿರ್ದೇಶಕರುಗಳು ಗೈರು ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಸಭೆ ಪ್ರಾರಂಭಿಸಲು ಕೋರಂ ಕೊರತೆ ಉಂಟಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ದಿನದ ಸಭೆಯನ್ನು ದಿನಾಂಕ 12/4/2021.
correct. So where is the quorum? Where is the quorum?
My lord, they are saying that, my lord, the only 5 members.
Morning session in some other matter. There were large number of directors, more than the quorum. But when the matter was taken up for that purpose, that is election of president or vice president, less than the quorum were present. We have interpreted it and
In
said,
that matter, for vice president, there was a quorum.
correct,
But subsequent to that, after 2 hours, for president, there is no. quorum.
there is no quorum.
They did not sign.
But
to
we held that at the time, that business, transaction of business, that is president election, that must be present. It's not,
My lord, 11 members are present on the day.
it's not relevant is what we have stated. It's at the time when that item is taken up for consideration, whether quorum is there or not. Here, when it was taken up for, it is not there. Anyhow, you take out notice, but have a look at the orders which I passed.
My lord, day after tomorrow, one more meeting is there. So I'm seeking stay for the further.
That
proceedings.
doesn't.
How can we now, now this is the same relief as much as, now what is there day after tomorrow?
My lord,
They have to call one more meeting.
Another one more
If
meeting.
there is no quorum in the first meeting, Lord.
Ah.
After 2 hours, they have to call one more meeting.
Same day next
Then
week.
after, within 7 days, they have to call second meeting.
at least, my lord, I am seeking opportunity to show the quorum on day after tomorrow.
No, let us see now.
If he shows the quorum that day, the meeting transact, then there is no issue about it.
No, correct. He's saying that according to him, on this day itself, quorum is there. So we'll hear the matter on Monday.
I agree, my lord. The record
He
shows
think-
that,
That
the
you get
record shows
instruction.
that there is a 5 members signed in that.
Correct.
ಇವರೆಲ್ಲ ಗೈರು ಹಾಜರಂತಿದೆ out of 11. But the bylaw says that 7 is a quorum.
My lord, out of,
So you complete your instruction.
Public,
We'll have it on Monday
public.
and that next meeting will defer it for the present.
Lord, may I request,
Ah.
if Lord wants to defer that,
Ah.
that is a process, it has to be taken out. And he is the beneficiary of that meeting.
No,
It
now
doesn't
the
mean that he will not be
next
selected that day.
meeting, in the next meeting, if you are confident that you can ensure quorum, then we will say that would be subject to the outcome of this. That's all.
Huh.
So that will take care of your interest.
please, my lord. Please,
Public.
The petitioner submits that
Even, my lord, we are made a representation to the respondent number 4.
let us see.
I will take notice for 1,
Yes.
3 and 2 and 3.
AG accepts notice.
Just I'm
One,
seeking,
two, and
my lord, give the opportunity to show my quorum on the next
So let
day.
us see.
He-
No, that is going to be held. That will make it subject to the outcome. Suppose you have quorum on the next date, there ends the matter. This will become infructuous.
Please,
If there is no quorum on that day,
please, my lord.
and then you get some order here, it will govern. AG
seeking just
accepts
opportunity.
notice for respondents, 1,
And 2, 3, my lord. Sorry, my lord, sorry, 3, 4, my lord, 2 is society.
1, 3 and 4. Emergent notice to the other respondents. Petitioners at liberty to take out notice by way of hand summons as well. Full stop. The counsel for the petitioner submits that in light of lack of quorum, which he however disputes, lack of quorum, meeting held on 28/3/2024 has been deferred and is likely to be reconvened on
Monday, 15.
Monday, sorry, 12th,
on 12th.
12th.
Full stop. In light of the same, it's made clear that the proceedings of the next meeting would be subject to further orders to be passed by this court, while clarifying that the meeting could still go ahead on 12th. Relist the matter on 15th or 16th?
In it, 15, my lord.
15th.
I'm seeking.
You
this-
have a look at, that order.
Obliged.
Seeking this order by hand delivery.
It will be uploaded.
Grateful.
Serial number 2,
I'm for the petitioners, my lords.
Last year.
My lords, matter has been settled between the parties, my lords. Yes,
Settled.
I may be permitted to withdraw the
Yes.
petition. Please.
Counsel for the petitioner.
Ma'am.
Memo, sir. We find a memo which reads as hereunder. In light of the same, petition is dismissed as having become infructuous.
Grateful.
three, where I am. Serial number 3,
Relist the matter on,
18th.
yes,
4, Uday Shankar.
ಇದೆಲ್ಲ case status check ಮಾಡಿ. Case status check ಮಾಡಿ, infructuous.
For Uday Kumar,
4, Uday Kumar.
for a petitioner in this case, Bengaluru in the Bangarpete transfer ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ.
What is the distance?
90 kilometers ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಒಂದು petitioner ಗೆ daughter ಇದೆ ಸ್ವಾಮಿ.
9,
Petitioner ಗೆ 2
what is
years,
the distance?
90 kilometers. Petitioner daughter ಇದೆ ಮತ್ತೆ old age parents ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ನೋಡ್ಕೊಳಕ್
Any children?
one child, daughter.
Age?
Yes, 2 years,
3 years.
2 years ಸ್ವಾಮಿ. ಅಂದ್ರೆ ಓಲ್ಡ್ ಏಜ್ ಪೇರೆಂಟ್ಸ್ ಇದ್ದಾರೆ, ಅವ್ರಿಗೆ ಇನ್ಕಮ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರ್ ಸೋರ್ಸ್ ಯಾವ್ದು ಇಲ್ಲ, ಮೈಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್, ಅನ್ನೆಸೆಸರಿ ಆಗಿ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಲೂರ್ ಕಡೆನೆ ಇರೋದು, ಬಂಗಾರಪೇಟೆಗೆ ನಾವು ಕೇಳ್ತೀವಿ.
Serve ಯಾವಾಗಿದೆ? Serve. The petitioner, wife, has sought for withdrawal of the proceedings in MC 145 of 2022. Filed by the respondent husband seeking dissolution of the matrimonial relationship before the court of the Civil Judge Senior Division at Bengaluru, and has sought for transfer of the said proceedings to the court at KGF, to the court of the additional senior civil judge at KGF, within bracket sitting at Bangarpet. Petitioner submits that she is residing at Bangarpet. And she has to travel a distance of about 90 kilometers to attend proceedings instituted by the respondent husband at Bengaluru, which causes hardship and inconvenience. It is submitted that in light of the child of tender age born from within the wedlock, who is now aged about
2 years.
2 years, the hardship caused in taking the child along to attend the proceedings, as the child cannot be left back, needs to be taken note of appropriately. This court in the case of MV Rekha is observed as follows. In accordance with the law laid down, convenience of the wife is required to be taken note of. Next, the assertion of hardship and inconvenience has not been rebutted by the respondent, who though served with notice has remained absent. In light of the same, case is made out to allow the petition, and accordingly, the proceedings in MC 145/2022 are directed to be withdrawn and made over to the court of additional senior civil judge at KGF, within brackets sitting at Bangarpet, which is stated to be the designated family court. Necessary records to be transmitted. Accordingly, petition is disposed of.
5, Kumar MD.
8/3/23.
ಪಿಟಿಷನರ್ ಮೇಲೆ ಇದರಲ್ಲಿ KGF ಕೋರ್ಟ್ ನಲ್ಲಿ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ KGF ಕೋರ್ಟ್ ನಲ್ಲಿ MC ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್
KGF to Bangalore.
KGF to Bangalore. ನಾನು ಇಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರ್ ಕೇಳ್ದೆ.
What is the distance?
Distance 100 kilometers.
100.
Respondent place ಇಂದ 100 kilometers ಇರ್ಬೋದು.
Any children?
Female child ಇದೆ. Child ಅವ್ರ ಕಸ್ಟಡಿನಲ್ಲೇ ಇದೆ. 10 years old. Harassment given by the respondent.
MC 7/23.
MC 7/23. Pending before the senior civil judge KGF. Petition filed by the husband against the wife.
You are working?
ಇಲ್ಲ ಗಾರ್ಮೆಂಟ್ಸ್ ಗೆನ ಹೋಗ್ತಾ ಇದಾರೆ ಈಗ ಪೇರೆಂಟ್ಸ್ ಜೊತೆ ಇದಾರೆ ಜಸ್ಟ್ ಗಾರ್ಮೆಂಟ್ಸ್ ಹೋಗ್ತಾ ಇದಾರೆ ಈ 9th standard or 10th standard ಅವ್ರು 8ನೇ ಕ್ಲಾಸು 9ನೇ ಕ್ಲಾಸು ಓದಿದ್ದಾರೆ ಅವ್ರೇನು ಗಾರ್ಮೆಂಟ್ಸ್ಗೆ ಹೋಗ್ತಾ ಇದಾರೆ ತಂದೆ ತಾಯಿ ಜೊತೆನಲ್ಲಿ ಇಲ್ಲೇ ಇದ್ದಾರೆ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಾರೆ ಅಲ್ಲಿ ಹೋಗಿ ಬರ್ಲಿಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅಷ್ಟೊಂದು ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ.
The petitioner wife has sought for withdrawal of the proceedings in MC 7/23 instituted by the respondent husband before the court of the senior civil judge at KGF, seeking for dissolution of the matrimonial relationship, and has sought for transfer of such proceedings to the family court at Bengaluru. Full stop. It is submitted that if the petitioner were to attend proceedings instituted by the respondent husband, she is required to travel a distance of about 100 kilometers, which causes hardship. Full stop. Further submitted that the petitioner is seeking out her livelihood in a job which would also be threatened, which would also be jeopardized if the petitioner were to frequently apply for leave and travel to attend proceedings at KGF. Next. Accordingly, it is submitted that the hardship be taken note of appropriately and orders passed as the travel interferes with her right of fair trial. More so in light of her precarious economic condition. Full stop. The respondent, though served, has remained absent. This court, next, this court in case of MV Rekha has observed as follows. In light of the same, the convenience of the wife is required to be taken note of. Next, the assertion of hardship and inconvenience of the petitioner has not been controverted by the respondent who, though served, has remained absent. Next, accordingly, case is made out. The proceedings in MC 7 of 2023 are directed to be withdrawn and made over to the family court at Bengaluru. Necessary records to be transmitted. Accordingly, petition is disposed of. Allowed.
Serial number 6, Jagadish Shetty, Balagangadhar GS.
For the petition, my lords.
The Lordship Counsel appearing for the respondent.
Yes,
The petition, my lords. My lords, the petition is the transfer of the OS 44 of 2022 on the file of Narsimrajpura Family Court to Chikmagaluru Family Court. my
OS
lords.
44,
Please, my lords.
filed by husband.
Husband, my lords.
Before, filed before court at
Chief Civil Judge and JMFC Narsimrajpura,
Chikmagalur, is it?
Narsimrajpura to Chikmagaluru, my lords.
Narsimrajpura.
Please, my lords.
Main central court number 10, UBC ಬರ್ತಾ main side ಬಂದು
What is the distance?
It's 85 kilometers, my lords.
Any children?
There are 2 children, my lords. Both of them have attained majority already.
The Lordship,
She is working?
No, my lord, she's unemployed.
the Lordship.
Just 1 minute. He's paying maintenance?
No, he's not paying maintenance, my lords. Maintenance is already being awarded before the Chikmagaluru Family Court, my lords.
Ordered.
Please, it's ordered. He has not been paying.
See,
And
miss? See, miss? In which proceedings?
Please, my lords. My lords, in CMS 765 of 2012, before the first additional civil
Seven?
judge. 65,
Of
2012.
how much is awarded?
The Lordship, and criminal review petition 615/17, it has been ordered at rupees
5,000.
10,000.
At
10,000.
Huh?
10,000, your Lordship.
10,000.
That
And,
was before this high court. Initially, it was 5,000, my lords. When an appeal was preferred before this court, it was enhanced from 5,000 to 10,000. And the arrears of rupees 8,50,000 as on 2019 is not being paid.
Your Lordship, regular deductions is made in salary of the respondent, your Lordship, by the government authorities, and the petitioner is receiving the said amount, your Lordship.
So now on what ground you are opposing?
My lords, all the petitions,
Let us see.
please, my
That's
lords.
anything else?
My lords, all the petitions that are being filed by the petitioner for maintenance are filed before Chikmagaluru Court, my lords. The respondent herein has already appeared before that court.
He has appeared.
Please, he has appeared.
Your Lordship, the respondent is working in health department, your Lordship, is working as a second division assistant in the office of the Taluk Health Officer, NRPura, your Lordship. And at the same time, he has been deputed to three other posts, your Lordship. PHC Magundi NRPura Taluk and PHC Kattinamane and PHC Magundi, your Lordship. Muttinakoppa, Magundi and Kattinamane has been deputed for 3 other posts, your Lordship, which are at 3 different places. As the respondent is being in the health department, emergency calls and immediate attention is necessary, your Lordship. And if the case is transferred to Chikmagalur, he'll be put to irreparable loss and hardship, your Lordship. He may not able to discharge his duties effectively, your Lordship. Hence, I oppose this, your Lordship.
But
And
now,
My lords,
even his mother is ill, your Lordship. She is 75 years old.
correct. Now you have to discharge your duties to your wife also.
Indeed, your Lordship. I have to work at the same time. I have to attend the court proceedings. I'm not denying that, your Lordship. If it is posted in NRPura, it will be easy for me to attend the court proceedings, your Lordship.
Marriage is troublesome, nothing is easy.
Your Lordship, indeed, your Lordship, but
So what we can do, now we will ensure that your presence is not required on every day, 1. 2, whenever you are required to go there, either in mediation proceedings or evidence, they will not seek for an adjournment. 3, in case the court should be accommodative, in light of the nature of your job. With these three conditions will impose so that your interest is taken care.
Right.
Yes,
Please, minutes.
the petitioner wife has sought.
Your Lordship, one more submission, Your Lordship.
Yes.
Even writ petition is there, Your Lordship, regarding to maintenance. It is in the final stage, Your Lordship.
Let us, the petitioner wife has sought for withdrawal of the proceedings in OS 44 of 22 pending on the file of the civil judge and JMFC Narasimha Rajapura and instituted by the respondent husband. Seeking dissolution of the matrimonial relationship and has sought for transfer of the said proceedings to the family court at Chikmagalur. Petitioner states that she is presently residing at Chikmagalur and if is to attend proceedings before the court at Narasimha Rajapura in OS 44 of 22 is required to travel about 85 kilometers, which causes hardship and inconvenience. Learned counsel for the respondent would submit that he is employed as a second division assistant in the services of the Taluk Health Office.
Health officer at NR, Your Lordship.
Taluk Health Office at NRpura. And that the nature of his duties are such that if proceedings are transferred as sought for, there would be hardship and inconvenience to the respondent and his employment would also be at jeopardy.
Your Lordship, indeed, he has been deputed to 3 other posts, Your Lordship.
It is further submitted that frequently he is deputed on various, frequently is deputed to different divisions of the department. And accordingly, it would be very difficult for him to attend proceedings if the transfer petition as sought for is allowed. Next. This court, in case of MV Rekha, is observed as follows. Next, accordingly, the convenience of the wife is required to be taken note of. If that were to be so, the distance of travel as noticed above is a matter of inconvenience of the wife that is required to be taken note of appropriately. It's further submitted that in proceedings relating to maintenance, the respondent husband has appeared before the court at Chikmagalur.
Indeed.
And such aspect is also required to be taken note of. Next. Where both parties face inconvenience and hardship. The convenience of the wife requires to be given precedence. Accordingly, case is made out for allowing of the petition and consideration of the request as sought for. Next. However, in order to mitigate the hardship of the respondent, it is directed as follows. Next. The petition A, petition is allowed. It is one nimisha. In order to mitigate the hardship of the respondent, certain directions are passed. Full stop. Next. Accordingly, it is ordered as follows. Proceedings in MC OS 44 is directed to be withdrawn. 44 of 22 is directed to be withdrawn from the court at Narasimha Rajapura and is directed to be made over to the family court at Chikmagalur. B. Once the proceedings are transferred, the court to which proceedings are transferred is not to insist on appearance of the respondent on all dates of hearing, except when the presence of the respondent is required, such as at the stage of mediation or at the time of evidence. Full stop. Next. When the respondent appears in person, petitioner is not to seek for adjournment. Next. It is made clear that in light of the nature of employment of the respondent as asserted, the court to which proceedings are transferred is to make reasonable accommodations for request for adjournments if made by the respondent due to reasons linked to his employment. Accordingly, petition is disposed of, necessary records to be transmitted forthwith.
Seven, Basuraj.
In this case, I'm appearing for the petitioner.
Last year.
Petitioner wife is seeking a transfer of MC7 of 2023 filed by the respondent from senior civil judge and additional CJ Mercikere to family court at Bangalore, my lord.
MC
7 of 2023
filed for
filed by the respondent herein,
what relief?
seeking a restitution of conjugal rights against the
Restitution.
petitioner.
From Mercikere to Bangalore.
Please,
What is the distance?
my lord, distance is about 200 kilometers. and
200.
She has a 9-year-old child. And moreover, the respondent is the permanent residence of the Bangalore only, my lord. You may kindly, lordship may kindly come to page 25, para 39. This is a restitution petition filed by the respondent herein.
Paragraph?
39, my lord. It is submitted that this honorable court is vested with the.
Just hold. Your pages are missing. Give your copy. I have only till para 22.
And my lord, petitioner has filed a 498 case. And charge sheet has been filed. Against that, the respondent herein has filed a criminal petition 9799 of 2023 before this honorable
Just
court.
1 minute. Now this petition is filed by the
A respondent husband.
So he is working here only.
Yes, he is working and he is the permanent resident of the Bangalore. Only that marriage as well took place in the Arsikere. For that reason, he has filed.
No, he has filed to Harasi.
Yes, my lord. And even after filing the 498, he has challenged the proceedings before this honorable court in criminal petition number 9799, where in past title also he has stated the address of the Bangalore.
Yes, the petitioner wife has sought for withdrawal of the proceedings in MC7 of 2023 pending before the court of the senior civil judge and additional CJM at Arsikere, and sought for transfer of such proceedings to the family court at Bengaluru. Petitioner submits that she is a resident of Bengaluru and traveling to attend the proceedings instituted by the respondent husband referred to above would involve travel of about 200 kilometers, which causes hardship and inconveniences her. Further submitted that from within the wedlock, they have a child who's aged about 9 years, who stays along with the petitioner, and leaving the child alone when traveling to attend proceedings to Arsikere also causes hardship. Full stop. It's further submitted that the respondent is also residing at Bengaluru. Next, the respondent, though served, has remained unrepresented by any legal counsel. Next, this court in the case of MV Rekha is observed as follows. Accordingly, the convenience of the wife is required to be taken note of. Next, taking note of the distance of travel of about 200 kilometers and that the petitioner has a child of 9 years. Clearly, convenience of the wife lies in having the convenience of the wife lies in having the proceedings transferred to Bengaluru as sought for. Next, it is noticed on a perusal of para 36 of the petition filed by the respondent in MC 7 of 23. Para 39, that there is a specific averment that the respondent herein is residing at Bengaluru. Full stop. Further, copy of the criminal petition 9799 of 2023 is filed along with a memo, which would also indicate that in the petition filed under section 482, the respondent husband has of Bengaluru. Accordingly, taking note of all such facts and noticing that the respondent has failed to controvert the assertion of inconvenience as made out, petition deserves to be allowed. MC 7 of 2023 are directed to be withdrawn and made over to the family court at Bengaluru. Child is, how old is the child?
9 years old, female child.
No, it says 2 years in the MC
9.
petition.
No, he has stated, but 9 years.
You file
Please, my lord.
a complete petition
Please,
in MC because pages are missing.
please.
The MC petition and 482 petition.
Please,
You file it now itself.
please.
8. Cell number 8, Ravindranath M.
For the petition. ನೋಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು. ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ಟ್ರೈ ಮಾಡಿದ್ವಿ, ಕಾಂಟ್ಯಾಕ್ಟ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಇನ್ಫಾರ್ಮೇಶನ್.
After 2 weeks,
ಎರಡು ಕೊಡಿ.
relist the matter on
23rd.
23rd.
9. Prakash.
Before petitioner, my lord. This matter is likely to be settled, my lord. Week after next, my lord.
Relist the matter at request on
23rd.
23rd.
Interim order make a
Interim order value grant is extended till the next date.
Please.
10. Serial number 10, Nanjumni Swami.
Really, kindly, my lord, the parties, my lord, I have taken back the entire file with me, my lord.
File a memo of retirement.
ಅದೇ ಅದು NOC ವಕಾಲತ್ತು ತಗೊಂಡೋಗಿದ್ದಾರೆ ಬಟ್ ಅವ್ರು ಹಾಕಿಲ್ಲ.
So file a memo of retirement. I'll have it on the next date.
Great.
Learned counsel for the petitioner submits that the petitioner has taken back all papers. Petitioner to file memo of retirement by the next date. Relist the matter on.
After vacation.
No, you file it. If they're not interested, why are you taking that headache?
24th.
24th.
Great.
11.
Sorry, my lord. Last vacation, I could not get the online things, my lord. That's why I could not appear before this call. I came from Hyderabad, my lord. This petition filed for transfer of the OS 157 of 2022 before the second of senior citizen Bellary to Bengaluru. This
Ballari to,
Bengaluru, my lord. Bengaluru direction of the citizen court.
what is the distance?
Distance because the different the case is different. My lord. Suit filed by the
What is the distance?
this
No, this is OS, is it?
OS, my lord. OS filed by the,
What is the stage of the proceedings now?
it is coming for evidence. Because of my injection petition was dismissed by the trial court, stating that the court came going to come to opinion that I have no evidence to prove my case. That's why I have,
Now, why are you
There is-
seeking, why are you seeking transfer?
because of there is a fair chance, please go to the page number 57 of the order,
Page?
page number 57. Discuss. In the injection petition, this IA, dismissed IA stating that the said issues needs to be considered. 57 of the said issues needs to be considered only after full-fledged trial. The plaintiff has to prima facie show his position of the suit state property. As there is a lack of documents to show that plaintiff is prima facie position upon the social property. This court is the opinion of that the chance of the plaintiff succeeding the suit is less. Totally came to conclude the IA.
Look, this cannot be a ground.
Because
Unless you say personally judge is prejudiced.
no, here whatever court came to conclude that
That's
I have
only
no
pri-
problem.
That's only prima facie.
No, clearly mentioned.
It has to be construed to be prima.
Court came to
It has to, otherwise how it can give, how
Of
it
course-
can give.
Of course, Miller, it
Prima
is-
facie, you have to make up your
it
mind.
is injection patient. The court cannot go to the merits of the case.
No, that's all on merits. Don't make such a submission.
I mean, I have the relaying the judgment of the Supreme Court, Miller.
No, what is this? I'll impose with 1 lakh cost. You take costs and go. I'm going to impose 1 lakh cost. It's not the way to file transfer petitions. If the court says prima facie, I'm convinced, chance of succeeding are less, so be it. It's only a prima facie observation. How can you say you want a different court? Absolutely not acceptable. Tomorrow you will tell to this court also. We
Mhm.
say that the chances of succeeding are less. What is wrong? It's only a prima facie observation. I am going to impose 1 lakh cost. You can do what you want. This is not at all a ground to seek for transfer of proceeding just because the court has made some remark. We are bound to make remarks when we say prima facie there is no case. How can you say that the court is prejudiced?
I am permitted to withdraw.
File a memo.
Mhm.
Counsel for the
Here.
petitioner
This post and name.
has
To be
filed a
semi-
memo which reads as follows. In light of the same, petition is dismissed.
Well, Gopal Krishnamurthy, Saraswati M.
You're appearing for petitioner, my lord. And for respondent. Discuss. My lord, respondent hearing is filed MC petition number 33360 of 23 before second additional.
So this was, does that come up?
My lord, a small submission, my lord.
No, I just want to know.
Yes, my lord.
It had come up yesterday, is it? Last week,
Monday.
Monday.
Yes, my lord.
And it was adjourned because
Because of to choose neutral place, my lord.
neutral place.
Yes, my lord.
Yes, yes.
We are ready to go for Hosdurga itself, my lord.
Hosdurga.
If they assure that they won't threaten
attempt.
or, if they assure that they won't threaten the respondent,
We'll ask them to file an affidavit.
please. And only at the time of evidence, my lord.
Yes, yes.
Sure, my lord.
So it will be, we'll allow it subject to condition.
Please,
One,
my lord.
affidavit will have to be filed by you and
From
parents.
Parents, please, my lord.
And parents.
Please.
That when they come there, there will be no untoward incident, nor will you threaten. One.
Please, my lord.
Two, when they come there, no adjournment is to be asked from your side.
Please, my lord.
And three, that their presence will be, is to be insisted only at the time of evidence
And
or
cross
mediation
examination.
when actually it is required.
Please.
Please, my lord.
The petitioner wife has sought for withdrawal of the proceedings in MC 3360 of 2023 filed by the respondent husband. seeking dissolution of the matrimonial relationship and pending before the family court at Bengaluru, and has sought for transfer of such proceedings to the designated family court at Hosturga. Full stop. Petitioner submits that she is a resident of Hosturga and the distance to be traversed to attend proceedings before the family court at Bengaluru is about
200 kilometers, my lord.
200 kilometers, which causes hardship and inconvenience. Full stop. Learned counsel Ms. Saraswati, appearing for the respondent, would strenuously contend that the respondent is an employee of the central government and would find it difficult to obtain leave. Full stop. It is also contended that there is animosity between both the sides, and on previous occasion, certain threats were held out by the petitioners. Full stop. However, the petitioner submits that such allegation made is contrary to facts. Next. Heard both sides. It is not in dispute that the petitioner is a resident of Hosturga and the distance of travel to Bengaluru would be about 200 kilometers. Full stop. This aspect of hardship is required to be taken note of in light of the law laid down in MV Rekha's case, which provides that the convenience of the wife is to be taken note of. Full stop. Accordingly, grounds are made out to allow the petition. However, the respondent has made certain assertions of threat by the petitioner and her family members, which requires to be addressed. Which requires to be addressed accordingly. Following order, the petition is allowed. The proceedings in MC 3360 of 2023 is directed to be withdrawn and made over to the designated family court at Hosturga. Next, it's made clear, however, that the presence of the respondent is to be insisted upon by the court to which proceedings are transferred only when presence is actually required, such as in the stage of mediation or at the stage of evidence. Next, it's made clear that when proceedings are conducted before the court at Hosturga and the respondent appears in person, petitioners are not to seek for any adjournment. Next, in light of the apprehension of threat as voiced by the respondent, the petitioner and her parents to file an affidavit that whenever the respondent appears before the court at Hosturga, no threats would be held out, nor would they create any hostile environment. Such affidavit to be filed within 10 days from today.
Please.
Accordingly, petition is disposed of.
13 urgent, 14 Onnapayas, Sunita H. Singh.
Why was it adjourned?
Lordship has granted enough opportunity to them to file their.
Why was it adjourned last
To
time?
file an affidavit with regarding to the presence of the petitioner in the particular company wherein I had given a notification from the company saying that it is compulsory for them to appear in person and not work through home. And twice they have filed an affidavit without giving a clear picture as to where is she working from and what is her kind of job. Though there is a clear statement made by her in her examination, in the cross-examination in a criminal case that she is residing at Bangalore and working at Bangalore, Your Lordship, they're not providing any particular information with regarding to her place of work. On the other hand, I have given all the material before your lordships to prove that she is working in Bangalore.
Let us see, we'll pass over.
Grateful, your lordship.
ಒಂದ್ಸತಿ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡ್ಬಿಡಿ.
ಆಯ್ತು.
15.
For respondents.
Requesting for prayer time, my lord, for Monday.
Without gonna appear up there.
ಬೇರೆಯವ್ರ ಹತ್ರ ಇಸ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
ಹೇಳ್ದೆ.
ಯಾರಾದ್ರೂ ಕೊಡ್ತಾರೆ ಗೌನ್. ಮೇಡಮ್ ಜಸ್ಟ್ ಲೆಂಡ್ ಯುವರ್ ಗೌನ್ ಫಾರ್ ಮಿನಿಟ್. ಹೋಗಿ ಗೌನ್ ಹಾಕೊಂಡ್ ಬನ್ನಿ.
ಹೋಗಿ.
Yes,
Kindly requesting prayer time for Monday, sir.
you want an adjournment.
Sir,
You want an adjournment.
yes.
Hmm?
Requesting prayer time,
When do you want it?
Monday, sir.
We'll have it on Monday.
18th, your lordship.
I'd request made on behalf of the petitioner. Release the matter on 18th.
Much of it.
Sure.
16. Serial number 16, Dilraj Rohit.
The case status check ಮಾಡಿ
Check ಮಾಡಿ.
Pass over.
Seventeen, Rupesh B.
Pass over adjournment. Pass over.
Eighteen,
My lord, seeking for the transfer of my lord's MC matter and GNWC matter from Family Court Bangalore to Family Court Hospital, my lords.
Bangalore to
Hospital, my lords. The distance is about 330 kilometers.
300.
330, my lords.
Shall I pass over? You just call him. If he's there, we'll take it up.
Please, my lords, please.
Pass over.
19.
For the petitioner in this matter, my lords.
Yes.
My lord, seeking for transfer of MC case, my lords, pending in Hassan to be transferred to Mysore, my lords.
Just 1 minute. From Hassan to?
Mysore, my lords.
He has been served only on 30th. We will have it next week. If he doesn't appear, we'll proceed to pass orders.
Please, my lords.
The respondent, for appearance of the respondent, relist the matter on 18th.
Please, my lords. There is an interim order in operation that may kindly be
Granted is extended till the next date.
grateful, my lord.
Serial number 20. 20.
Week's time granted for necessary compliance. Yes.
21.
Super director has to appear before the registrar on around 15th.
Wants a refixing of date.
On 18th it may be taken because
In
17th
fact,
holiday.
date was fixed for Monday. My learned brother has not.
Some function is there because I was
Date was fixed.
not aware of that. Wednesday, it may be-
17th ಅಂತ ಇದ್ರೆ 17th ರಜೆ ಇದೆ.
17th ರಜೆ ಇದೆ, 18th.
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 The matter is this court, while allowing the
IA filed for.
Permission.
allowing the applications for recall and reopening the case had fixed the date for inquiry on 15/4/2024. Full stop. Matter was moved, submission made that the court may refix the date on 18th. In light of said submission, the date for inquiry stipulated as 15/4/2024 is to be now taken to be as 18/4/2024. Accordingly, all orders passed on IAs in the CPs to be read, to be taken, to be read in terms of the modification made above. ಪ್ರತಿಯೊಂದರಲ್ಲೂ ಆರ್ಡರ್ ಮಾಡಬೇಕು ಇದೇ ರೀತಿ. ಇದು 4-5 ಮ್ಯಾಟರ್ ಇದೆ. ಪ್ರತಿಯೊಂದರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್. ಅಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಆನ್ so and so, request is made to refix the date. Accordingly, date is refixed as 18th and the modification to be order dated so and so to be read in terms of the modification.
Interim order section till next date ಅಂತ ಇತ್ತು. Interim order till next date ಅಂತ ಇತ್ತು.
Interim order is extended till the next date.
Serial number 22.
It's a small town, Ramnagar.
Steps to be taken for issuance of notice through court. Full stop. Petitioner is permitted to take out hand summons. Notice by way of hand summons. Proceedings are stayed, is it?
Stayed, my lords. I think that may be continued, my lords. Stay
Stayed.
after stay.
Already stayed.
Yes, my lords. Till the next date it was stayed. And this is a matter which is filed by the husband. Divorce proceedings are filed by the husband in Ramnagar court.
Interim order earlier granted is extended till the next date.
Reopening, my lords. The date may be fixed. Reopening.
Date week after next date.
24th.
Before.
Much of it.
23.
23 they have
You have
filed.
served on the council before the trial court.
My lords, we tried serving on the council, on those particular dates, the council does not appear. And
Let us, yes.
23. Nagaraj T.
Yes, filed memo for withdrawal.
Counsel for the petitioner has filed a memo which reads as follows. In light of the same petition is dismissed as withdrawn. AG is permitted to file memo of appearance within 10 days.
Published.
Harish NK.
Please, Lords. I appear for the second respondent.
Yes.
This matter was listed day before yesterday, my lord, where it was, my lords, brought to the notice of this honorable court that, my lords, the compromise petition entered between, my lords, the petitioner and the second respondent is stayed in a 482 petition, my lords. And the petitioner is before
Petitioner and
the second respondent society, my lords. The petitioner is before your lordships on the ground that, my lords, his memo for disposal of the proceedings before the registrar was dismissed. He had moved a memo on the ground that, my lords, the matter was settled between the parties. And, my lords, the society had undertaken, my lords, to...
where is that memo? Memo?
Memo, my lords, the memo is that...
Page number 23, my.
Page 23.
3, Annex F, my lord.
Where is the order of stay in the?
That is furnished on the last date of hearing.
482 petition?
That furnished, my lords. On the last date.
On previous last date of hearing, my lords, my colleague has submitted it.
Yes.
Matter. No, it is not served to me.
The copy is.
Where is the order sheet in the CC in the criminal proceedings?
Page number 22, my lord.
22.
Annex E. Page 20, Annex E. Relevant portion at Annex number 22.
So now this will have to be disposed of, stating that proceedings will regarding the settlement can be pressed, liberty would be reserved to press for consideration of memo depending on the outcome of the proceedings in 482.
Please, my lord, please. Till then, the proceedings can be continued.
Yes.
Please,
My lord,
please.
if it is disposed like that, they will proceed with the dispute here.
That I'll observe.
Second response.
I'll observe. The proceedings can go on.
No, they will proceed with then
No, the proceedings in the main dispute will have to go on, not in the CC proceedings. Here, now the proceedings before the joint register must continue.
no,
Please.
my lord.
Yes, sir.
Joint memo filed in the year 2021, my lord.
Yes, counsel, that joint memo is now stayed in the 482. So there cannot be disposal of the proceedings by way of settlement.
Till disposal of that criminal petition, this matter may be kept pending, my lord.
That how why should you? That you
critic-
seek for appropriate relief, not in this proceeding. You have to go ahead. However, we will state that final orders not to be pronounced till the outcome of the 482.
Please.
Yes.
Now you appear for?
Second respondent, my lords, along with my colleague, the society, my lords.
Now you appear for the petition.
Petitioner.
So all these are identical orders.
Identical
They are
orders.
challenged.
Identical.
Identical orders. The society is
different numbers.
Different number, case numbers, my lord.
Different case
only the
numbers. Identical
creditors, my lords.
Compromise petitions. my lord.
So we have to pass separate orders.
Separate
Please,
order.
my lord.
Identical.
Please, my
Yes.
lords. One more submission, my lords. My lords, not in all cases the interim order is granted. Few matters are listed on, my lords, 16th. The criminal petitions, 482 petitions.
No, now there's a stay in which of the matters? All matters or?
No, first matter.
The first matter.
Only three matters, my lords.
Which
Out
three?
of which the first matter, my lords. Only the first
that-
matter.
Only 24.
Please, my lords.
So now 24 can be disposed of.
Please, my lords.
The other matters?
My lords, they are listed on the criminal petitions are listed on 16th, my lords.
Okay, we'll see those
Please, my
separately.
lords. Please, my lords.
Seal number 24 is to be dealing and taken up separately. The present writ petition has been filed. seeking for issuance of a writ of certiorari to set aside the order dated 13/3/2023 in the dispute pending before the Joint Registrar of Cooperative Societies at Annexure A, whereby the memo for disposal that was filed came to be rejected. On the ground, came to be rejected, full stop. Next, it is the case put forward by the counsel for the petitioner that the parties had entered into a settlement and joint memo was filed, which was taken note of in the proceedings in CC 565 of 21. And proceedings in CC were closed, in the criminal case were closed. As it is submitted that the subject matter in the criminal complaint as well as the dispute were the same, the petitioner had sought for closure of the proceedings in the dispute, which memo, however, has been rejected on the ground that the proceedings in the criminal case and the dispute were different. Full stop. Next. However, it is brought to the notice of this court that the order closing the proceedings in the criminal complaint has been stayed in criminal petition 101197 of 2023. Full stop. In light of such subsequent development, petition is disposed of, taking note of the stay of the order passed in the criminal case in criminal petition number 101197 of 2023. Full stop. While it is made clear that the proceedings in the dispute number so and so, annexure A, can proceed. However, no final award to be passed till orders in 482 in criminal petition 101197 of 2023 are finally pronounced. All contentions are kept open.
Obliged, my lords. Great. May I request other matters, my lords, to be listed on 22nd or 20th.
The other matters to be delinked and relisted on 22nd
Interim order may be extended. Interim order is pending, that may be extended.
in all matters.
All matters.
Pending interim orders in operation are directed to be extended till the next date.
One more matter.
Obliged.
WP 5821/23, that may be
Office
connected.
to put up WP number
5821/23.
along with these matters.
Obliged.
Weeks time granted.
He has been served on the side.
Weeks time granted for necessary compliance.
26. 26.
Yes.
We'll have it,
I represent respondent 3 society, Your Honor.
we'll have it next week. There's some office objection raised on your statement of objection.
Yes.
Comply, we'll have it next week.
Not complied, Your Honor.
Next week we'll have it.
Okay.
Relist the matter on
Because there is a stay, Your Honor. It has to be
25th.
vacated.
the interim order earlier grant is extended till the next date.
27.
Comply ಮಾಡ್ಬಿಟ್ಟು next hearing.
Weeks time granted to do the needful.
28. But there are
Lord, may I request? 27 and 28 has become infructuous.
Infructuous.
Why it is become infructuous, my lord? They got an right to vote by order dated 21/10/23. There, that condition was not there, my lord. These are like, ಅವು ಗೊತ್ತಿಲ್ದೇನೆ ಎಲ್ಲೋ ಬಂದಿದಾವೆ ಇವಾಗ. That both has become infructuous. ಅದ್ರಲ್ಲಿ ಕಂಡೀಷನ್ ಇರ್ಲಿಲ್ಲ ಈಗ ಪ್ರೆಸೆಂಟ್ ಆರ್ಡರ್ ತರ. ವೆಕೇಶನ್ ಅಲ್ಲಿ ಆಗಿರೋದು ಇದು. ವಿಂಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲಿ ಆರ್ಡರ್.
Now they voted, we don't know.
They voted, even they are not voted, it will become infructuous because they voted. Then there is no dispute from any of the person. So it has become
So
infructuous.
just find out
27.
if the results are announced, there ends the matter.
I think ಇದರಲ್ಲಿ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡೋದು ಅದೇನು.
No, we have not stated, but if the results are announced, take note of it.
No, result is already announced because they will announce.
Sir, my lord, it's become infructuous. Already election has been on.
You file a memo
Yeah.
and just mention whether results are announced.
Calendar of events says that the
Just find out. I'll have it on Monday. You file a memo and whether results are announced.
Okay.
Relist the matter on Monday. 7/28 also.
28.
oblige me.
28.
28 also.
28 also. No.
29. Basuraju.
Yes, for the petitioners council.
Yes.
The petitioners 1, 2, and 3 an order is passed on 31/10/23 disqualifying them from being continued as directors of respondent number 4 society. Under section 17(3). Then, my lord, petitioner number 4 and petitioner number 4 is disqualified by an order dated 31/10/23 on the same date. Under section 29C, on the ground of violation of bylaw number 43 of supply of milk.
Bylaw number?
Bylaw number 43.11.
Which provides for?
That is annexure K1, I think 180 days supply of milk, my lord. I'll just point.
For non-availing of services.
Non-availing of services, that is supply of 180 days milk.
Yes.
Petitioner number 5, who was co-opted as a director in the vacancy, existing vacancy, that co-option is set aside. He was co-opted on 8th September 2012. 22.
Now this is set aside.
Set aside. Date no. Even. I'll just give the date, my lord.
9/11/2023.
Yes.
Your Lordship may kindly see section 16.
Yes.
Subject to the provisions of section 17, no person shall be admitted as a member of a cooperative society except the following, namely: A, an individual who needs the services of such cooperative society, and this, Your Lordship may kindly notice, this is an amendment which came into by Act 3 of 2013 with effect from 11/2/2013, and is residing in the area of operation of the society. An additional condition was added on 11/2/2013.
Both are cumulative.
And is competent to enter into contract, etc. Then, my lord, kindly go to subsection 3. Making an application in writing, all those things are there. Kindly see section 17, my lord. No person shall be eligible for admission as a member of a cooperative society if he, one of the condition is E. This was also added by amendment which came into force on 11/2/2013. Is not eligible for membership under section 16. That is for fresh admission. Then your lordship may kindly see subsection 2.
So this 17E is a disqualification in case he is ineligible.
He is ineligible under section 16 for admission. Then under section 17, when he applies for membership, they have given the qualifications for admission. Then, my lord, subsection 2 may kindly be seen. If a member becomes subject to any disqualifications specified in subsection 1, he shall be deemed to have ceased to be a member from the date when the disqualification was incurred.
Yes.
If a member becomes subject to any of the disqualifications specified in subsection 1, he shall be deemed to have ceased to be a member from the date when the disqualification was incurred. Then subsection 3. If any question arises as to whether a member is deemed to have ceased or has ceased to be a member under subsection 2 or 2A, the registrar may either so moto or on a report made to him, and after giving an opportunity to the person concerned of being heard, decide the question. So adjudication is also provided under 17(3).
But there is some slight ambiguity in the language insofar as 17 talks of disqualification. However, it says no person shall be eligible for admission as a member. So suppose a decision is taken not to admit him, then 17 doesn't operate.
Doesn't operate. But if there is a person already admitted, subsection 2,
Notwithstanding that he is disqualified under 16, still if he is admitted, then under 17(2) you can have him disqualified.
Disqualified. Now the situation is petitioners 1 to 3 are disqualified under section 17(3).
What is under?
Under 17(3), on the ground that the petitioners are ineligible for being a member as they are not residents of that area of operation.
Now an inquiry is held.
Now, order, yes, inquiry is held and order is passed. Situation, your lordship may kindly see. Petitioners 1 to 3 were members from long prior to this residence becoming a qualification.
All the 1 to 3.
1 to 3. Petitioners 1 to 3 are members of respondent number 4 society long prior to section 16 being amended, adding 16(1)(a), adding, and is residing in the area of operation.
What is the date of their membership?
According to this thing, my lord, they are members from prior to
No, that is not in dispute.
The first petition are 2012, madam. According to them. only.
petitioner number 1, 2012.
Then the others are 15, 16 after the act amendment.
Puttaswamy, that is petitioner number 2, 2015. Third petitioner during 1995. The other petitioners, that is petitioners 8, 9 and 12, were also enrolled as members in 95, 96.
Petitioner number 1.
2012.
The petition number 1 and 3.
1 and 3
are earlier to the
amendment.
And this can't have retrospective effect. Is what you're saying.
That is the first this thing.
Yes.
Then, my lord, your lordship may kindly see the date of the orders. Now, the other order is passed in respect of petitioner number 4.
Yes.
In the order, the orders are at an order under 29C was passed at Annexure A, initially on the complaint of one Srimati Lakshmi.
This is in so far as petitioner number 4.
This is in respect of Rupesh Vinamanasegaru. That is in respect of petitioner number 1.
5/7/21. Yes.
Yes, 5/7/2021.
That he is disqualified.
He is disqualified. Against that, an appeal was filed under Annexure B. Appeal was allowed by the order dated 26/11/2021. Again, now a proceeding is initiated by filing a dispute under Section 70 of the Act.
Liberty was granted or?
No. It now a dispute is filed under Section 70.
Yes.
Interim order.
Earlier it was 29C, now it's 70.
Now it's under Section 70.
Yes.
Against, in that dispute, an interim order was passed at Annexure C. Restraining the first petitioner from functioning as an elected representative by staying this malad. That was challenged in WP 19/758 of 2022. An interim stay was granted. Then I was sent back to Karnataka Appellate Tribunal to file it as a review.
Yes.
Thereafter, it appears by an order at 5/8 dated 5/8/23. Six. Three ಅಲ್ಲ page number 59. On a petition filed by, on a memo filed by that Ratnamma. Typed copy is at page 74. Dispute itself was dismissed. On a memo filed by that Ratnamma to withdraw the
Closing the.
after all this, the another person, Paramesh and Sarojamma, they file a complaint before the respondent that first petitioner is removed from membership by the general body. And on that ground, they want the first petitioner to be removed.
Pending the case, no? It's pending.
Yes. That is page 75. On 15(9) itself, he takes up the matter. ರೂಪೇಶ್ ಅಧ್ಯಕ್ಷರು ಇವರ ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯ ಹೊರಗೆ ವಾಸ ಇರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಪೂರಕ ದಾಖಲೆಗಳನ್ನು ಐ ಆಮ್ ರೀಡಿಂಗ್ ಇನ್ ಪೇಜ್ 76 ಮೇಡಮ್. ಪೂರಕ ದಾಖಲೆಗಳನ್ನು ಸಂಘದ ಕಡೆಯವರು ಅಲ್ಲಗಳೆ ಪೂರಕ ದಾಖಲೆಗಳನ್ನು ವಿಚಾರಣೆಗೆ ಹಾಜರುಪಡಿಸದರ ಕಾರಣವನ್ನು ಮಹಾಸಭೆ ದಿನಾಂಕ 11/12/20 ಮಹಾಸಭೆಯಲ್ಲಿ ಇವರ ಸದಸ್ಯತ್ವವನ್ನು ವಜಾಗೊಳಿಸಿರುವುದರಿಂದ ಇವರು ಕಲಂ 17ರಂತೆ ಇವರ ಸದಸ್ಯತ್ವ ನಿಂತು ಹೋಗಿದೆ ಎಂದು ಭಾವಿಸಿ ಆದೇಶಿಸಿದೆ. He issues that order 31/10ಕ್ಕೆ ಆದೇಶವನ್ನು ಕಂಪ್ಯೂಟರೀಕರಿಸಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಿದೆ. That is annexure F. ನಮ್ಮ ನೋಟಿಸ್ ಆಗಲಿಲ್ಲ.
After inquiry.
After inquiry. So removal is under section 17(3).
Yes.
Same person, Paramesh, had filed a complaint dated 1/9/22 as against the second petitioner on the ground that general body has removed them on 1/12/2020. Same order is passed at page 81 on 15/9/23. Order is issued on 31/10/23. Again under section 70.
On same grounds.
Same ground.
Similar orders.
Same verbatim, same typed copies, cut and paste. In respect of three, annexure J. In respect of petitioner number 3, the complaint is filed Parmesh has filed the complaint. Same allegation that general body has passed a resolution. Order is at annexure J. Page 98. Unique order sheet illa. Annexure J at page 99 on the same date 31/10. Of course, reference is made to the complaint said to have been filed by Parmesh and Puttaswamy Gowda.
Yes.
This is again under section 17 according to them. Page 102, your lordship may kindly see. Very same Sarojamma files a complaint against petitioner number 4. That he has not supplied $500 of milk in a period during a period of 180 days, thereby violating answer.
This is on a different ground.
This is under 29C, but the order date is 15/9. ಕಂಪ್ಯೂಟರೀಕರಿಸಿ ಆದೇಶವನ್ನು 31/10 ಹೊರಡಿಸಿಯಾರ. K1 ಯಾರಿಗೆ? ಯಾರಿಗೆ? K1? ಹ್ಮ್. ಇವನಿಗೆ ಯಾವ್ದಿದು ಕೋಆಪ್ಷನ್ ಎಂದು? ಆಪ್ಷನ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ವಿ. Action cancel. 31. Separate order. Now, your lordship may kindly peruse page 123, annexure M. ವಿಷಯ ಸೋಗಾಲು ಪಾಳ್ಯ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಸಹಕಾರ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ದೇಶಕರುಗಳ ಸದಸ್ಯತ್ವ ರದ್ದಾದ ಹಾಗೂ ಕಾಯ್ದೆ ಕಲಂ 29C ಕ್ರಮದಿಂದ ಅನರ್ಹಗೊಂಡ ಮತ್ತು ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ದೇಶಕರ ರಾಜೀನಾಮೆಯಿಂದ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಕೋರಂ ಕೊರತೆ ಉಂಟಾಗಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖ ಶೋಭಾ ಕೋಮ್ ಹೇಮಲಿಂಗೇಗೌಡ ಇವರ ಮನವಿ. ದೆನ್ ಇವೆಲ್ಲ ಆರ್ಡರ್ಗಳನ್ನ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ದೂರು ಅರ್ಜಿ ಮತ್ತು ಅದರ ಮೇಲೆ ಆಯ್ದ ಆರ್ಡರು.
The administrator continues.
ಹೌದು, ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಈ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಸೊಸೈಟಿ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ ಚೀಫ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ವಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಟು ಶೋ ದಟ್ these 3 persons have been co-opted: Siddegowda, Umesh and Lakshmamma. This co-option records according to them were not produced, and therefore it is taken that they are not, there is no co-option.
Yes.
Then your lordship may kindly see ಮುಂದುವರೆದು ಸಂಘದ ಮತ್ತೊಬ್ಬ ಇದು ಐ ಆಮ್ ರೀಡಿಂಗ್ ಪೇಜ್ 124 ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ. ಮುಂದುವರೆದು ಸಂಘದ ಮತ್ತೊಬ್ಬ ನಿರ್ದೇಶಕರಾದ ನಾಗರಾಜು ಬಿನ್ ಚಿಕ್ಕೈದೇಗೌಡ ರವರು ಸಂಘದ ಬೈಲಾ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಅನ್ನು ಉಲ್ಲಂಘಿಸಿ ಹಾಲು ಸರಬರಾಜು ಮಾಡಲು ವಿಫಲರಾಗಿ ಸಂಘದ ನಿರ್ದೇಶಕರಾಗಿ ಮುಂದುವರಿಯುತ್ತಿರುವ ಕ್ರಮವನ್ನು 29C58 ಉಲ್ಲಂಘನೆಯಾಗಿರುವುದರಿಂದ ಉಲ್ಲೇಖ 5 ಕಚೇರಿಯ ಆದೇಶದನ್ವಯ ನಿರ್ದೇಶಕ ಸ್ಥಾನ ನಿಂತು ಹೋಗಿತ್ತೆಂದು ಆದೇಶಿಸಿದ್ದು, ದಿನಾಂಕ ಸದರಿ ಅವರ ನಿರ್ದೇಶಕ ಸ್ಥಾನ ತೆರವುಗೊಂಡಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದ ರೂಪೇಶ್ ಗೌಡ, ನಿರ್ದೇಶಕರಾದ ಚಿಕ್ಕಣ್ಣಾಚಾರ್ ಮತ್ತು ಪುಟ್ಟಸ್ವಾಮಿ ಇವರು ಬೈಲಾ 25(1) ಅನ್ವಯ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯಲ್ಲಿ ನಿವಾಸಿಯಾಗಿರದ ಕಾರಣ 17(3) ಅನ್ವಯ ಪ್ರಾಥಮಿಕ ಸದಸ್ಯತ್ವವನ್ನು ವಜಾಗೊಳಿಸಿದೆ. ಸೊ 3 ಇವರು 4 3 ಜನ ಕೋಆಪ್ಟೆಡ್, ಇವ್ರದ್ದು ಕೋಆಪ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹಿಡಿದು ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಒಟ್ಟು ಸ್ಥಾನಗಳಲ್ಲಿ 7 ಸ್ಥಾನಗಳು ಮೇಲ್ಕಂಡಂತೆ ರಾಜೀನಾಮೆಯಿಂದ ಮತ್ತು ಅಧಿನಿಯಮ 29C ಅಧಿನಿಯಮ 17 ಪ್ರಕಾರ ಅನರ್ಹತೆ ಹೊಂದಿರುವುದರಿಂದ ಮತ್ತು ಸದಸ್ಯತ್ವ ರದ್ದತಿಯಿಂದಾಗಿ ತೆರವಾಗಿ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯನ್ನು ನಡೆಸಲು ಕೋರಂ ಕೊರತೆ ಉಂಟಾಗಿರುವುದರಿಂದ ಆಡಳಿತ ಮಂಡಳಿ ಸ್ಥಾನದಲ್ಲಿ 31(1) ಅನ್ವಯ ಸಂಘಕ್ಕೆ ವಿಶೇಷಾಧಿಕಾರಿಯನ್ನು ನೇಮಕ ಮಾಡುವುದು ಸೂಕ್ತವೆಂದು 9/11/23 ದೇ ಪಾಸ್ an order appointing the special officer under section 31.
Number 213, 23/9/2022 ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿ
ಎಲ್ಲಿದು
ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ ಒಟ್ಟು ಹೇಳಿದ್ದೇವೆ.
ಎಲ್ಲಿ ನಿನ್ನ ಹತ್ರ ಐತನು?
It is this order that you have challenged.
All these orders we have challenged, pointing out the proceedings are taken up in a way, a premeditated this thing to appoint administrator. Arrangement is made to appoint administrator by passing orders against 4 elected directors under 17(3) and 29C. As regards the co-opted directors, under Annexure M, he holds co-option itself is not available.
Malifieds, yes.
Therefore, he appoints. Now the defense taken is, all these are appealable orders, appeal can be filed.
Now, is there any interim relief granted? No.
No, at that stage, caveator had, there was a caveat filed and therefore it was felt that matter could be heard, but that did not happen.
Subject to result of
Government, you have taken a stand.
Lord, I am taking a stand, Lord, but I have not filed my objection because since it is a 2023 matter, I have taken time for filing objection. I did not receive the para-wise, one thing, Lord. And another thing, Lord, everyone who is having inability, he says that it's a bias and malafide intention, Lord. The one thing, the question which is arisen, which is only, it has to be factually has to be taken out whether they are ineligible or not. That has to be done in a way of appeal, my lord. That is one aspect. And another aspect is that, my lord, Annexure F, G series, my lord, that is a 70 proceedings. There is an appeal provision for that. And H, my lord, it is a 70 proceedings. That is also appealable order. And K1, my lord, K1, that is 29C proceedings. That is also appealable order. And M, which is a circumstantial order where there is no quorum, because of that reason, M has to be passed. M has to be passed. That is one thing, my lord.
M is a combined order, setting aside the co-option as well as appointing administrator.
All co-option is, they would have challenged it before appropriate authority. That is one aspect. Lord, in another aspect is that the learned senior counsel has argued that the law is whether retrospective or prospective, my lord. Lord, section 72, which makes any person disqualify if he is a disqualified person. Assume a moment, someone has taken a membership. He is continued to be as a member of the, he has continued and working as a salaried employee for this said cooperative society. Then section 17(2) will apply if he is disqualified under section 17(1)(f). 17(1)(f). And these are all disputed facts, my lord. We doesn't know whether they are belongs to same area or they are resident of the same village or other village. It has to be disputed question. It has to be decided, my lord. Assume a moment. I will read one order, my lord, at annexure G series. One order ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಒಂದೇ ಪ್ಯಾರಾ ಓದ್ತೀನಿ, ಜಾಸ್ತಿನೂ ಓದಲ್ಲ. At page 80, my lord, the first order, my lord. F. Annexure F, first order, my lord. I will read only para 5. May I read, my lord? ಪ್ರಕರಣದಲ್ಲಿ ದೂರು ಅರ್ಜಿದಾರರು ದೂರದ ಅರ್ಜಿಯಂತೆ ಸಲ್ಲಿಸಿರುವ 75 ಚನ್ನಪಟ್ಟಣ ಸೋನ್ಸೋ ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರ ಸೋನ್ಸೋ ರೇಷನ್ ಕಾರ್ಡ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ವರದಿ ಮತ್ತು ಸೋನ್ಸೋನೆ ಸಾಲಿನ ಸಂಘದ ದಿನಾಂಕ ಸೋನ್ಸೋನೆ ವಾರ್ಷಿಕ ಸಭೆ ನಡವಳಿಯಲ್ಲಿ ಪರಾಮರ್ಶಿಸಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಶ್ರೀ ರೂಪೇಶ್ ಬಿನ್ ಸಿದ್ದೇಗೌಡ ಇವರು ಕೊಪ್ಪ ಗ್ರಾಮದಲ್ಲಿ ನಿವಾಸಿಯಾಗಿದ್ದು ಸೋಗೋಪಾಲಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಸಂಘದ ಸದಸ್ಯತ್ವವನ್ನು ಪಡೆದು ಸದಸ್ಯರಾಗಿ ಮುಂದುವರೆದು ಪ್ರಸ್ತುತ ಸಂಘದ ನಿರ್ದೇಶಕರಾಗಿ ಅಧ್ಯಕ್ಷರು ಮುಂದುವರೆದಿದ್ದು
orders what you say are appealable, you are correct, but what about appointment of administrator which they have challenged?
Yes, my lord. My lord, may I assume a moment, my lord? If there is no quorum, my lord, then the society cannot take a decision under Rule 14 AK. It will not be as the decision is taken without any quorum. To day-to-day activity, there should be a special officer, that is, my lord, the intention is not as senior counsel has put out before this court that the officer has intended to put a special officer to the society. That is not the fact. Where these order was passed and the subsequent to that, the society is not able to run day-to-day activity, then special officer has to be appointed. Assume a moment, my lord, in another cases where the members of the societies were resigned. The decision is unable to taken by the members of the society. If there is no quorum, the society cannot transact its business without any quorum. Because of that reason, the M is passed. M is only protrated that it is subsequent, it is a first order. Apart from that, the annexure G to H. Everyone will come before this court and they say that this is the officer has done. Where is the material to show that the officer has done? He has gone beyond his power. Where is that? These are all the disputed question, my lord. My lord, I have to bring this the one thing before this honorable court. This matter was heard on lengthy first hearing date because the order passed are in 2023. Because of that reason, this honorable court has not granted a stay in first occasion. And even that order says that you can take a chance in vacation bench. They did not do that. And of course, bench is changed and they can have that argument before any bench. The main object is that, my lord, assume a moment, lord, if he is not able to be a member under section 16, my lord, if he is not in a area of operation, he cannot become a member at all. Assume a moment, he was there earlier, but for some other reason, he went in another area of cooperative society. Can he say that, no, I will be here and there also? Can a member of the society become a two cooperative society member? Because of that reason, that 16 is in operation. He cannot be outside the operation of cooperative society.
Otherwise, one thing can be done subject to, without expressing any opinion. We will grant limited interim prayer, let them go before the appellate authority. Let the appellate authority decide on the interim relief finally. Till then, orders to be kept in abeyance.
Lord, may assume a moment, Lord. The cooperative society structure is a democratic structure. It is like it will come from the root of the nation, my Lord. The complaint made by the one member of the society and a disqualified person can seek such a stay before this court. He is a disqualified means he is disqualified. He is not a member at all. Can he have a benefit of that?
Yes,
Anyhow, there is an
yes, yeah,
special
yeah.
officer is appointed to
hear,
that
I'll hear.
society.
I'll hear.
Public.
With kind permission, madam.
Yes.
So, kindly see
But you
section
should have
20
filed your statement of objection.
My Lord, I
How can
agree.
you not file?
My
when
Lord,
they're making serious allegations.
my Lord, I
about
agree, my Lord.
Your conduct.
My Lord, I agree, my Lord. I have a right to that. I bought a original records, but I sought them for paraphrase remarks. They had to receive a paraphrase remarks, but because of that reason, it took some time, my Lord. That is the only reason.
It is. Yes.
So, kindly see section 27, my lord, the power of the annual general body. Section 27.
So we'll see. So now I've heard them. Now I'll hear you. I'll fix a date and hear you. Then we'll see what is to be done. By then
Even annexure M is also an appealable order under section 106.
let us see. Let us see. But you will have to take your stand.
My Lord, I will take.
We'll have it on 22nd at 2:30. By then you must file your
Obliged,
statement.
I will. Without fail, I will make sure.
Then we'll see. Let's see what they
Please.
take in writing. State. To file the statement of objections by the next day is the matter at 2:30 on 22nd. And in that other matter, Siddharth, you'll have to file your statement in that constitutional validity. Now that the matter is adjourned.
Lord, that is ready, my Lord. Only officer has
So,
to sign.
correct.
Today he signed.
Now
I will
since it's
file.
adjourned,
I will file.
you can file it.
I will.
And that legal position, please examine.
Please.
That MSME Act.
Actually, MSME loan and scheme for MSME loan is a separate section. Nationalized banks, etc., are to give. In this, he did not approach for the loan as MSME, nor was it granted under that category.
Lord.
But anyway, I will place all those things
But
by.
the section appears to indicate that the bank must.
That is in respect of MSME loan, separate directions are given, what can be the interest rate, etc. All those things are there. This is not a MSME loan sanctioned.
Lord, adding to the senior counsel that the notification is read out on that day, my Lord, it is not at all applicable to the present case because there is a committee. When he himself thinks that my company is going under stress, he should make an application before
But
that
just
he's going under stress.
examine that because it appears.
It is not the bank. should
MSME,
make.
ಅವರು MSME ಹೌದು ಅಲ್ಲ ಅನ್ನೋದೇ dispute ಇದೆ. But anyway, as MSME loan ಬೇರೆ category ಇದ್ರದ್ದು. They are registered as MSME, then only loan will be granted.
Let us. Yes.
Serial number 30, Shailesh, yes, AGA, 30.
Petitioner, Lord, in this case, notice was issued and the auction purchaser is before this honorable court. He is not duly represented. What has happened is
You appear for the bank.
I appear for the bank. What has happened is the fourth respondent, he has taken a loan and he has defaulted. Subsequently have obtained an award and in execution of the award,
the property has been sold and sales certificate has been issued by the assistant registrar to the fifth respondent.
He is the auction purchaser.
He is the auction purchaser.
He's not served, but
He served, auction purchase is also served, he is also before the court, but he is not duly represented by any counsel.
they are auction purchaser. Original. Then let him engage a counsel.
I have no objection.
Are fine.
My only difficulty is this. The auction purchaser has purchased this property paying 1 crore 86 lakhs.
Chandrappa?
Now let him engage a counsel.
Please, my lord, please, my lord. I was only bringing one fact to the notice of the court. That the auction purchaser who has purchased, he has paid 1 crore 86 lakhs. Now, that was paid on 15th May 2023. Now it is almost a year since he has made the payment. Still, we are not able to give him possession. Because the assistant registrar says, I am not able to do. Only a short question of interpretation of Rule 38, my lord. That's the only question that is there.
Borrower, who's the borrower?
Borrower is fourth respondent.
What has happened to his notice?
When I went to serve the notice on him, he refused to take the notice.
The notice to R4 nodi. So we'll have it, we'll fix a date, we'll ask the office to put up what is it.
Please, my lord.
Officer to put up report regarding notice issued to R4. R5 is present in person and submits that you would engage a legal counsel.
Lord, I have also filed an affidavit saying that the fourth respondent, when I went to serve, he has refused to take the notice.
Let us see.
It may be kept on a short date, my lord.
Date good.
23.
Or sign the order sheet. Yes.
31.
Dave process setting, not 31 is covered, my lord.
Short for a short
One is
pass over,
covered.
my lord, is in total 17.
Passover.
Yes.
Passover.
Hearing 32. Prasanna VR.
Petition numbers. Short correction needed, my lords. Instead of OS, my lord, it is mentioned as MC at para number 1 and 7 of the judgment notes. Preamble, my lord, it is correctly spelled, my lords.
OS 251.
How? OS 251 of 2020. Para number 1 and para number 7, my lords.
Para number
1 and para number 7. Para number 1, my lord, internal page number 2 of the judgment. Similarly, my lord.
That's all. That's all.
Only.
The counsel for the petitioner has filed IA 1 of 24 seeking for correction of the description of the proceedings. Full stop. Perused the memorandum of facts in support of the application. In light of the admitted proceedings on record, the order of 6th March 2024 is modified to the extent as below. Wherever the words within inverted comma MC 251 of 2020 are found, same to be replaced by the words OS 251 of 2020.
Please.
Full stop. disposed of. The order dated 6th March 2021 to be read subject to the modification as ordered while disposing of IA 1 of 20.
Please.
33.
Appearing for the petitioner, my lord. Lord, the instant writ petition was originally filed seeking a writ of mandamus to implement an order dated 13/3/2023 that was passed by the Bbmp respondents.
This
2024, it was disposed of with a specific observation that the appeal that is pending before the Commissioner Bbmp under 253 be disposed of as expeditiously or as fast as possible. But however, so far that has not happened, number one. Despite that not, in spite of that not happening also, the grievance of the petitioner today before my lords is very simple. The reason why originally the writ petition was preferred was to implement an order dated 13th March 2023, where a demolition order was passed by the Bbmp respondents. Insofar as R5's illegal construction that deviated from the sanctioned plan, which they had obtained in 2022. This writ petition was filed on 27th October 2023 by the petitioner. On 31/10/2023, my lords, there was an interim order passed by this honorable court directing R3 and R4 to ensure no further construction is put up. And on 13/12, my lords, 13/12/2023, an IA was preferred by the private respondent, which is the respondent number 5, seeking certain modifications of the interim order passed on 31/10/2023, my lords. However, that IA was rejected, and subsequently, the interim order that was passed on 31/10/2023 continued. In January, there were some developments that happened, my lords, where spot inspection of this particular property was made, including the property of the petitioner. And on prima facie, which a copy of that mahazar, the spot inspection report that was prepared, was not given, a copy of that was not given to the petitioner. In any event, my objections were also not filed to that. But however, considering all of these things, on 5/2/2024, this honorable court disposes of the writ petition with a direction to the Bbmp to complete the hearing in the appeal. The appeal is the order against the order dated 13/3/2023, where the demolition order was passed. That was challenged by the private respondent under 253.
Now, what are you seeking now?
All I'm seeking is that a modification of the final order of 5/2/2024, wherein an interim order may be extended until the completion of the appeal before the Bbmp. That's all I'm seeking for.
You serve.
My lords, I have been served, my lords.
Who
I beg to
appeals
appeal
for
for the Bbmp, my lords.
My lords, one more reason as to why this particular IA was filed, my lords, is that.
Let us see.
Yes, my lords. Yes, ma'am.
Who appears for the 5th respondent?
Mr. H.C. Shivaramu was appearing.
I'll have it on Monday once more. I'll relist it on Monday.
All right, my lords. My lords, the only reason why.
What do you say? He's
My
saying
lords,
that.
the instructions are only internal, some painting work is going on, and
my lords,
no construction, my lords.
there is some exterior construction work. I have produced photographs pertaining to that. See,
Permit
it's
me
at
to
page
complete,
number
my lord.
8, my lords, of this present IA that I have filed.
So in the interim or in the appeal, is there any order of stay?
No, my
Yes, my
lords.
lords. An order of status quo is there, is what I've been instructed, my lords. I'll place the proceedings before the appellate authority also, my lords.
We'll have it on Monday.
My lords, on 6th, the hearing is there before the commissioner, my lords. In any event, my lords, despite, I understand my learned friend is saying that there is a status quo, but in spite and despite of all of that, my lords, they are hectically proceeding with doing all these interior, exterior work day and night, my lords.
No, now that you will have to take action. Now,
Yes.
he need not bring it to your notice. Status quo means status quo. It
Please,
doesn't
lords.
mean you can continue it. He need
May
not come
may only request, my lords. My lords, we have tried to go to the site, and whenever we have gone to the site, they have vanished all of a sudden. And then when we move out, my lords, what we have been instructed by the petitioner is they again start continuing with the construction. My lords, we are unable to.
You take police assistance and enforce your order.
Yes, my lords. My lords, if only that could be recorded, my lords, I will direct the.
That correct, that we'll record in the presence of the other side. But I'm
Please.
saying, don't feel helpless. If there's any interim order, it's your duty to enforce it. He need not come here.
My lords, it is,
Yes, my
they are
lords.
failing miserably at it, my lords. That is why I'm before my
See.
lords, my lord.
We'll see. But then you take your action and report by Monday what action you are taking. He
Please,
need not
please.
come to the court for non-enforcement of your own interim order. Now
I
you
understand.
take police help. Why we should pass an order?
My lords, and I've also been given to understand that the husband of R5 is a Bbmp contractor. It's, I just wanted to bring that point on.
Yes, now you report on Monday what's happening.
Please.
Relist the matter on Monday.
Much
R5 to take stand insofar as the IA filed by the petitioner. You have served copy.
No, my lords, we'll make sure.
Serve copy. Yes.
Grateful, my lords.
Copy of application to be filed on R5.
34 Arjun, 35 Venkatesh R. Mahesh Kiran Shetty.
In this, I am for the petitioners, my lord.
Yes.
My lord, in this case, actually, due to continuous leave, he couldn't get the loan approval, my lord, or else we would have settled it off.
My lords could kindly go through the order sheet. But from 2014, the same submission is made that they are going to settle the matter. In fact, my lord, 2014 sale has taken place. Confirmation is stayed by this honorable court. It's a society wherein, my lord, the recovery amount is more than 20 crores. And the money belongs to the members who have deposited money from 1970s. My lord, it is a misappropriated funds which are sought to be recovered. He, during the subsistence of attachment before judgment, sells the property in favor of the petitioner hearing. My lord, it is all because the very sale deed itself is void because it is during the subsistence of the attachment. And moreover, my lord, there is an alternative remedy. And before challenging the sale, my lord, the payment of the entire sale amount along with 5% solatium is the condition precedent, which, my lord, unless they do that, they could not have challenged the sale itself, even before this honorable court or even before the authorities. Anyway, my lord, a submission is made across the bar that, my lord, the purchaser is an advocate. For that reason, my lord, I have been very considerate for all these reasons. If at all they could mobilize and deposit the money within time, I could have shown some consideration. I could have convinced the society. Now the situation is this, my lord, that I can't even convince the society to that effect. For that reason, my lord, my respectful submission would be, whatever the remedy they have, alternative remedy, let them go before the appropriate forum. There also, my lord, they can deposit the amount and...
Yes, what
my lord, we were discussing settlement process, my lord. This is happening little bit along, but here he has approached the loan. Bank has got some delay, my lord. It would have been settled at the earliest, my lord.
That is your headache, madam. That's not their headache. That's
But already we are in the process of settlement. We have discussed on settlement, my lord. One date, if it is given, next hearing, we will possibly try to settle it up, my lord.
If you don't go ahead on the next date, then we will have to proceed with the matter.
Please, my lord.
It's made clear that unless concrete steps are taken and placed on record regarding the proposed settlement, the court would be constrained to proceed with the main matter itself. Relist the matter finally on 22nd.
Please, ma'am. Oblige.
My lord, 23rd, my lord.
23rd.
Please.
B group 36. Mithun. Respondent number 4 in this matter.
This is that other matters, isn't it? Yes, let us see. That's argument is going on. We'll see.
36.1. Once again, the name has been shown as Satish Kumar. Satish Kumar is no more. Satish Kumar is dead. Despite of me filing.
2 times.
2 times it has. ಹೋದ್ ಸತಿ ಸರಿಯಾಗಿ ಬಂದಿತ್ತು. ಈ ಸತಿ ಪುನಃ they have shown us ಹೋದ್ ಸತಿ ಸರಿಯಾಗಿ ಬಂದಿತ್ತು. ಈ ಸತಿ ಪುನಃ they have inserted the name of Satish Kumar.
They'll ನೋಡಪ್ಪ. I'll just pass over.
Yes, Miller.
Let
230
us see
Miller.
what arguments they do. Or 2:02. Connected, same. 230.
Problem.
$37. Connected matters.
Respondent number 3. This matters, your lordship. This, the coffee board should answer, your lordships.
No.
Who appears?
My coffee board is ready, my lord. This is, all the petitioners are the members of society, my lord. They borrowed housing loan on the basis of long-term loan, my lord. And the union government has introduced a scheme, net relief scheme for the coffee growers, and who have borrowed money for the construction of houses in the rural areas. This was on 10/4/2010, my lord. The scheme contemplates, my lord, the grower must be a small grower and the liability must be less than 5 lakhs. And the borrowing must be prior to 2002, my lord. These petitioners are eligible for a waiver of 50% by the union government through the coffee board. They have no objection. They have cleared many claims made by the members, my lord. Now the petitioners before your lordship are also similarly placed like the others whose benefits 50% was waived by the coffee board. Even for these petitioners also they are liable to, they are agreeable. Insofar as the 70 out of 75%, 25% was to be borne by the financial institutions which has availed loan to the borrowers. Now we have filed the case, my lord, before against the society. Society shifting their burden that to the federation, my lord. Now the federation and the society has to answer to remaining 25%. Coffee board is already agreed and they have filed objection before this honorable court statement saying that they will give benefit of 50%. Now the dispute is regarding 25%. Now only the society has to refer all the claims of the members, my lord, to the coffee board. Then the coffee board in turn will consider the eligibility criteria, whether they are coming under the purview of the scheme. If the members are entitled, then they have to give the concession. Now the society is, in spite of there is a direction by this honorable court in these proceedings to send the papers within 15 days.
There is an synopsis I have filed, your lordship, in that.
They are not forwarding the papers to the coffee board, my lord.
I appear for the federation.
Now the society has filed a petition seeking a direction to the federation, saying that we were only acting as a postman. We were entitled for only commission in the loan transaction. The federation has availed the loan, so federation has to pay the remaining 25%.
The federation avails it from other financial institutions like LIC at rate of 1%, your lordship. It is immaterial who repays us. Somebody should repay the money.
Yes, exactly.
As regards the federation, it is immaterial whether the borrower pays or the primary society for which he is the member pays. It is immaterial. Whatever amount is due, if it is 25% or 70%, whatever is due from coffee board, etc., whichever institution.
Under the government order which they are relying, who has to bear?
In that, your lordships, that 50% as regards that submission, the coffee board has to reimburse it to the federation. And in fact, in some cases, the names also have been forwarded to the coffee board, your lordships.
Who appears for the coffee board?
Anupama madam appears.
No, who appears for the society?
Federation, I appear.
Mr. Rahul Karyappa was appearing now.
Mr. Muttanna, TP Muttanna is representing. On the last
okay.
occasion, he had represented.
So let him come in his presence, we'll see what.
Yes.
But there are
and
three
one more
other
thing,
connected matters which are similarly placed, connected matters which are not being listed, your lordships. I'll pass on the numbers, even they may be taken up. And one more submission, your lordships. In some cases, I have filed NOC Wakalat for the federation. The earlier council's name is also forthcoming in the cause list, your lordships. 37.5, your lordships. In some matters, earlier council's name, Mr. Bhaskaraya's name is shown in the cause list.
Should be deleted.
That should be deleted, your lordships, wherever it is being shown.
In light of submission that Mohammed Tahir
please
has filed wakalat for R3 in all the matters. Office to delete the name of learned counsel M.K. Bhaskaraya,
Please.
who is the earlier counsel for the third respondent. Now this Muttanna's name will direct it to be shown, or has
No,
he
He has
undertaken?
not
to file?
filed power, I think.
Huh?
He has not filed.
He's the arguing counsel.
Huh.
He's not been reflected here in the cause.
So whose name is on record then?
Rahul Kare, Bharti Patil.
Petitioner.
Who?
First petition, first petition,
Petition.
37.
37.
Yes.
Bharati Patil.
Vinita, no.
Bharti
The
Patil.
37 is Bharti Patil. They,
Bharti Patil.
society has filed a petition.
They filed the petition.
Yeah, I'll
seeking-
have it next week.
Yes.
Appear for Bharti Patil.
Yes,
So then you ask the arguing counsel to be present.
ma'am.
Relist the matter on 22nd.
My lord.
Please.
When 18th or 19th, my lord.
On 18th,
Please, please,
the same stage.
please.
Interim orders may be extended.
Interim orders in operation is extended till the next date.
Applies.
Otherwise, this matter, we can refer for mediation.
In fact,
Then sort it out. If now in case federation says the society has to pay, society.
Now the federation
and then the
says,
government.
my lord, they borrowed from LIC of India.
in fact, in
That has
each
to
case,
be-
I have prepared, I have asked the federation, they have prepared, if we waive, if they are ready to, they are ready to waive off the penal interest, etc. What would be the amount if they are ready to, if they are willing to settle it in
My lord,
one time? That particular information also I have got from the federation.
my lord, many of the borrowers are ready to discharge the my lord, subject to condition as per the scheme, my lord. The arrears has to be calculated as on 30/9/2010. And this 25% has to be paid by the borrowers. If 75% is waived off by the union government and the financial institution, many of the petitioners will discharge the remaining 25. Now they say we have to pay up to date interest also from 2010.
Let us.
Yes.
38, Arjun, 39, Mohammed Tahir, S.C. Shivramu.
I appear for the petition. Synopsis on the last date of hearing, your lordships. Lordships had asked because the allegations made in the 64 inquiry report and the 68 re-audit notice were one and the same, your lordships. Lordships may kindly take page number 13, your lord. That is annexure A. This is the representation dated 14/2/2019.
You have furnished him the synopsis.
Synopsis, so I furnished a copy of the synopsis.
No, now he has given one table. You have a look at it.
Lord, that is only I am saying, Lord. Whatever table he has given in first allegation under section 64, this is not an 64 inquiry. It is 63 subclause 13, my lord. There is only inspection in respect of the looking at the what he submitted in earlier occasion. That is only related to that aspect. 64 inquiry covers entire the transactions which is done by the society in that time period, my lord. It's only,
Inquiry has
it's
been
only
conducted and
limited to
those
the,
allegations have been
Now
dropped.
it's the stage of auditor, cooperative audit, somebody is appointed.
howdo.
He's
It's
now
only
looking into
to re-inspect the audit report, that's it.
On the same allegations which have already been dropped. That is
No.
my submission, your
No,
lordship.
correct, but why can't you place the same thing?
Your lordships may kindly bear with me. Annexure A may kindly be taken. I'll take your lordships through the allegations made. This is the representation made, your lordship, dated 14/2/2019, allegedly by some of the members of the petitioner society. They've submit a representation to the respondent number 1. Based on this representation, on 18/3/2019, the respondent number 1 addresses a letter to the registrar cooperative societies. That is, your lordships would get it at page number 23. He addresses a letter to the registrar stating that look into these allegations. Immediately on 1/8/2019, a 64 inquiry notice is issued. That is at page number 24, your lordships. Now, your lordships may kindly come to the allegations made, Aropagalu. Lordships may kindly take this along with the synopsis which I have filed. The first allegations. I'll read the Kannada. ಸಂಘದ ಉಪನಿಯಮದಲ್ಲಿ ಸದಸ್ಯರಾಗಲು ಅದೇ ಸಂಸ್ಥೆಯಲ್ಲಿ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದ ಅತ್ತಿಬೆಲೆ ಹೋಬಳಿ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಾಸಿಸುವಂತರವರು ಮಾತ್ರ ಸದಸ್ಯರಾಗಲು ಅವಕಾಶವಿರುತ್ತದೆ. ಆದರೆ ಉಪನಿಯಮ ಉಲ್ಲಂಘಿಸಿ ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಮೀರಿ ಅರ್ಹರಲ್ಲದ ಎಲ್ಲರಿಗೂ ಶಾಲೆಯಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡುವವರು ಹೊರ ರಾಜ್ಯದವರನ್ನು ಸದಸ್ಯರನ್ನಾಗಿ ಮಾಡಲಾಗಿದೆ. The first allegations as per this, your lordships. In the second one, ಸಂಘದ ಉಪನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಅರ್ಹರಲ್ಲದವರಿಗೂ ಸದಸ್ಯರನ್ನಾಗಿ ಮಾಡಿಕೊಂಡು ಸಂಘದಲ್ಲಿ ನೈಜ ಸದಸ್ಯರಿಗಿಂತ ಅನರ್ಹ ಸದಸ್ಯರೇ ಹೆಚ್ಚಾಗಿದ್ದು, ಈ ಕಾರಣಗಳಿಂದ ಪ್ರತಿ ಸಾಲಿನ ಚುನಾವಣೆಯಲ್ಲಿ ನೈಜ ಸದಸ್ಯರಿಗೆ ಯಾವುದೇ ರೀತಿ ಮಾನ್ಯತೆ ಸಿಗುತ್ತಿಲ್ಲ. The second allegation is that, and similar allegations. Third allegation, ನ್ಯಾಯಾಲಯದ ಖರ್ಚುಗಳು ಎಂಬುದಾಗಿ ರೂಪೀಸ್ so and so ಖರ್ಚು ಮಾಡಲಾಗಿರುತ್ತದೆ. ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಮತ್ತು ಅಧ್ಯಕ್ಷರು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಖರ್ಚುಗಳನ್ನು ತೋರಿಸಿ ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. With regard to the legal expense incurred by the petitioner society. That is at second in the 68 order, your lordships. ಸಂಘವು ಶಾಲಾ ಕಟ್ಟಡದ ಮುಂಭಾಗದಲ್ಲಿ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ರೂಪೀಸ್ so and so ಗಳನ್ನು ಖರ್ಚು ಮಾಡಿರುತ್ತದೆ. ಆದರೆ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳಿಂದ ಮುಂಗಡ ರೂಪೀಸ್ so and so ಜಮಾ ಬಂದಿರುತ್ತದೆ. ಈ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳು ಕಟ್ಟಿರುವುದು ಮಳಿಗೆಗಳ ಬಿಡ್ನಿಂದ ಬಂದಂತಹ ಹಣದಲ್ಲಿ ಮಾತ್ರ ನಿರ್ಮಾಣ ಮಾಡುವುದಾಗಿ ಉದ್ದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಈ ಎರಡರ ವ್ಯತ್ಯಾಸ ರೂಪೀಸ್ so and so ಗಳನ್ನು ಸಂಘದ ದುಡಿಮೆಯ ಬಂಡವಾಳದಿಂದ ಖರ್ಚು ಮಾಡಲಾಗಿದೆ. ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ಸಹಕಾರ ಇಲಾಖೆಯಿಂದ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲ. That is the third allegation, your lordships. Third allegation in the 68 order and fourth allegation in the 64 order. Next, ಸದರಿ ಸಂಸ್ಥೆಯ ವಾಣಿಜ್ಯ ಮಾಜಿ ಅಧ್ಯಕ್ಷರಾದ so and so ಮತ್ತು ಕಾರ್ಯದರ್ಶಿಯವರು ಕನ್ನಡ ಮಾಧ್ಯಮದಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿದ್ದ ಮಕ್ಕಳನ್ನು ಆಂಗ್ಲ ಮಾಧ್ಯಮಕ್ಕೆ ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ವರ್ಗಾಯಿಸಿರುತ್ತಾರೆ. ವರ್ಗಾವಣೆಯಾದ ವಿದ್ಯಾರ್ಥಿಗಳಿಂದ ಶಾಲಾ ಶುಲ್ಕದಲ್ಲಿ ಹಣ ದುರುಪಯೋಗ ಮತ್ತು ಕನ್ನಡ ಮಾಧ್ಯಮದ ತರಗತಿಗಳನ್ನು ಮುಚ್ಚಿರುವ ಬಗ್ಗೆ. ನೆಕ್ಸ್ಟ್ ಶ್ರೀ ಜೈಭಾರತಿ ಶೈಕ್ಷಣಿಕ ಸಹಕಾರ ಸಂಘದ ಸದಸ್ಯತ್ವ ವಿದ್ಯಾಸಂಸ್ಥೆಗಳ ಅವಿನೀತಿ ಹೊಂದಿರುತ್ತಿರುವ ಬಗ್ಗೆ ಮತ್ತು ಸಂಸ್ಥೆಯ ವಾಹನ ಖರೀದಿ ಪರ್ಚೇಸ್ ಆಫ್ ವೆಹಿಕಲ್ಸ್, your lordships. That is there in the other inquiry report as well. For this notice, your lordships, I submit a detailed reply. That is at annexure D, page number 27, 30/11/2019.
Just finish up the remaining.
The allegations, sir. Yes. Seventh one, ಸಂಘದಲ್ಲಿ ಬೋಧಕಿಯರು ಸಿಬ್ಬಂದಿ ಇದ್ದು ಇವರಲ್ಲಿ ಬೋಧಕ ಸಿಬ್ಬಂದಿಯವರಿಗೆ ಯಾವುದೇ ಗ್ರಾಚ್ಯುಟಿ ಬೋನಸ್ ಇತ್ಯಾದಿ ಅವಕಾಶ ಮಾಡುತ್ತಿರುವುದಿಲ್ಲ. ಆದರೆ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿಯಾದ ನಟರಾಜ್ ಇವರಿಗೆ ರೂಪೀಸ್ so and so ಗ್ರಾಚ್ಯುಟಿ, ರೂಪೀಸ್ so and so ಬೋನಸ್ ಹಾಗೂ ರೂಪೀಸ್ so and so ರಜಾ ವೇತನ ಒಟ್ಟು ಆಗಿದೆ. ಈ ಬಗ್ಗೆ ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶ ಕಲ್ಪಿಸಿರುವ ಕುರಿತು ಪರಿಶೀಲಿಸುವುದು. 8th allegation. ಸಂಘದ 2017-18 ಸಾಲಿನ ಸರ್ವ ಸರ್ವ ಸದಸ್ಯರ ಮಹಾಸಭೆಯನ್ನು ಸಹಕಾರಿ ಕಾಯ್ದೆ ಅವಕಾಶಗಳಂತೆ ನಡೆಸಿರುವುದಿಲ್ಲ. ಕಾಯ್ದೆ ಕಾನೂನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಸಂಘದ ಸದಸ್ಯರಿಗೆ ಅವಶ್ಯಕ ಮಾಹಿತಿ ಒದಗಿಸಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈಗಾಗಲೇ 1819 ಸಾಲಿನ ವಾರ್ಷಿಕ ಮಹಾಸಭೆಯನ್ನು 36/2019ಗೆ ನಿಗದಿ ಮಾಡಿ ನಡೆಸಲು ತೀರ್ಮಾನಿಸಿರುತ್ತಾರೆ ಕುರಿತು ಪರಿಶೀಲಿಸುವುದು. ಸಂಘದ ಕಾರ್ಯದರ್ಶಿಯಾದ ಸೋ ಇವರು ದಿನಾಂಕ 19/8/2017 ರಿಂದ ಫೆಬ್ರವರಿ 2018 ರವರೆಗೆ ಕೆಲಸಕ್ಕೆ ಗೈರು ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಈ ಅವಧಿಯಲ್ಲಿ ಸಂಘದ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ಯಾವ ರೀತಿಯಾಗಿ ನಡೆದಿರುತ್ತದೆ ಮತ್ತು ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ವಿರುದ್ಧ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯು ಏನು ಕ್ರಮ ಕೈಗೊಂಡಿರುತ್ತದೆ ಎಂದು ಪರಿಶೀಲಿಸುವುದು. ಈ ಮೇಲೆ ತಿಳಿಸಿರುವ ವಿಚಾರಗಳ ಅಂಶದಲ್ಲಿ ವಿಚಾರಣಾ ವೇಳೆಯಲ್ಲಿ ಕಂಡು ಬಂದಿರುವ ಲೋಪದೋಷಗಳನ್ನು ಬಗ್ಗೆ ಈ ಕಚೇರಿ ಗಮನಕ್ಕೆ ತಂದು ಹೆಚ್ಚುವರಿ ಆರೋಪಗಳನ್ನು ನಿಗದಿಪಡಿಸಿಕೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಿದೆ ಅಂಡ್ ಆದೇಶ.
What happened to this report?
This report, Your Lordships, I filed my detailed objections to this report and subsequently I complied with all these, each particular allegations were complied with me. I filed a compliance report and these allegations were dropped. Your Lordships may kindly take Annexure H, page number 121. Dated 29/3/2021. The operative portion, Your Lordships, would start at page number 140.
Now, after the inquiry, 68 proceedings were initiated.
68 proceedings were initiated. I furnished a compliance report also, detailed compliance report. On submission of my compliance report, Your Lordships, the following order came to be passed. Lordships has page number 140.
140.
140, Your Lordships. Annexure H1. ಆದೇಶ. May I read it? ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 6/12/2016 ಅನ್ವಯ ಹಾಗೂ ಸಹಕಾರ ಸಂಘ
125/789 drop.
15789 ಸಂಘದ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಕೈಬಿಡಲಾಗಿದೆ ಹಾಗೂ ಆರೋಪ 6 ರಲ್ಲಿ ಒಂದು ಶಾಲಾ ವಾಹನ ಸಂಘದ ಸ್ವಾಧೀನದಲ್ಲಿ ಇಲ್ಲದೆ ಪ್ರಾದೇಶಿಕ ಸಾರಿಗೆ ಅಧಿಕಾರಿಗಳು ಜಪ್ತಿ ಮಾಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ವಾಹನ ಮಾರಾಟ ಮಾಡಿರುವುದರಿಂದ ವಸೂಲಾತಿ ಕ್ರಮವಿಡಲು ಆಡಳಿತ ಮಂಡಳಿ ಮತ್ತು ಕಾರ್ಯದರ್ಶಿಗಳಿಗೆ ನಿರ್ದೇಶಿಸುತ್ತಾ ಕಲಾಂ 69 ಅಧಿಬರ ಕ್ರಮ ಆದೇಶಿಸಿತು. That recovery proceedings, surcharge proceedings under section 69 were directed, Your Lordships. It is at this stage another representation, Your Lordships. Your Lordships would kindly take page number 144. (30/10/2019). This was issued to again the petitioner society. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ಜಯಭಾರತಿ ಶೈಕ್ಷಣಿಕ ಸಹಕಾರ ಸಂಘ ಸೋ ಅಂಡ್ ಸೋ ಆನೇಕಲ್ ತಾಲೂಕು ಇದರಲ್ಲಿ ನೀವು ಕಾರ್ಯದರ್ಶಿಯಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುವುದು ನಿಮ್ಮ ಸಂಸ್ಥೆ ಆಫ್ ಮೆಂಬರ್ಸ್, ಚುನಾವಣಾ ವೆಚ್ಚಗಳ ಬಗ್ಗೆ, ವಾಣಿಜ್ಯ ಮಳಿಗೆ ನಿರ್ಮಾಣ ಖರ್ಚುಗಳ ಬಗ್ಗೆ, ಹಳೆ ವಾಹನ ಖರೀದಿ ಬಗ್ಗೆ, ನ್ಯಾಯಾಲಯದ ಖರ್ಚುಗಳ ಬಗ್ಗೆ, 1718 ಸಾಲಿನಲ್ಲಿ ವಾರ್ಷಿಕ ಮಹಾಸಭೆ ನಡೆಸದೆ ಬಗ್ಗೆ ಇರುವ ಬಗ್ಗೆ, 7 ಕಾರ್ಯದರ್ಶಿಯವರು ಗೈರು ಹಾಜರಿ ಬಗ್ಗೆ, ಶಾಲಾ ವಾಹನಗಳ ನಿರ್ವಹಣೆ ಸಂಬಂಧಿಸಿದಂತೆ ಲಾಗ್ ಪುಸ್ತಕದಲ್ಲಿ ಲೋಪದೋಷಗಳ ಇರುವ ಬಗ್ಗೆ, ಅನಾವಶ್ಯಕವಾಗಿ ಕಟ್ಟಡ ರಿಪೇರಿಗಳು, ಶೌಚಾಲಯ ರಿಪೇರಿ ಇತ್ಯಾದಿಗಳಿಗೆ ಲಕ್ಷಾಂತರ ರೂಪಾಯಿ ಖರ್ಚು ಮಾಡಿರುವ ಬಗ್ಗೆ, ಹೀಗೆ ಹಲವಾರು ಅವ್ಯವಹಾರಗಳು ಮತ್ತು ಲೋಪದೋಷಗಳ ಬಗ್ಗೆ.
Now, insofar as there appears to be some overlap. Insofar as what has been left out earlier, stating on whatever reason, leaving out that whatever fresh allegation, let it continue.
I agree, Lord. If
Before
it
that,
is
your
60
lordships.
That of course you'll have to examine.
No, no,
You
no,
have
my
to
lord.
examine.
No.
To what
Only
extent
one
there's an-
thing I'm submitting, my lord. I agree what my lord has said, that if it is a second inquiry, is a 64 inquiry. This is not an 64 inquiry. I will read 3 provision, my lord, that makes clear who has to do those inquiries and whether those inquiries are a similar nature or not. That I want to put it before this court.
Can
Whether the
member-
inquiry conducted under 64, if it is similar to 65 inspection, or it is similar to 63, or 63-13 is different, my lord, that is a re-audit. 63-13A is only an inspection to that extent to re-verify the audited accounts. My lord, this section 64 doesn't go into the matter which is where audited. The audit department is separate, and the authority who conducts under 64 inquiry, he is a separate, my lord. I will show that. The
What is-
authorities are different, and the object of the inquiry is too different, my lord. Here, nothing will be, extra remark will not be made. Whatever he submitted the
Wow.
audit report, and what is the to the supportive to his audit report, the receipt will be seen,
So
that is
correct.
a
Now,
re-verification, my lord.
What do you say regarding their argument
No.
that under 64, if it is left out, then you can't, you cannot reopen those question by way of audit?
I will
My-
read that.
my
The
submission-
provision I will read, my lord.
One more aspect
And I
which
will read.
the
He
lordship
cannot,
should,
he cannot say that something is conducted under section 64, that is a different inquiry. This is a different inquiry.
Can membership
This
be
is
gone into
nowhere
by
related.
auditor, your lordships?
ಅದು ಬರೋದೇ ಇಲ್ಲ ಅಲ್ಲಿ. Membership ಬರೋದೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
That is one of the allegations.
We cannot go into that. Lord, one thing I want to tell before this court. Lord, this is order passed under section 63 capital A. That is only re-verification of audit report. They will re-verify, they will check it out whether he's given a equal receipt, what he submitted the audit report, that they will only re-verify. I will read that provision only. I will read 3 provisions.
Just, we
Very
can do one thing. We can keep it pending. Let them continue with it and place the report before the court. Let's say examine.
My humble submission is that the auditor, can he go into the aspect of whether the general body was conducted in accordance with law?
Correct. Insofar as that you point out, let him take instruction. If it is beyond the scope of the audit powers.
With regard to making a enrollment of membership, etc., can auditor go into that?
Can be. It can be, my lord, whether they paid a fee or not, that will be put in the audit report.
That aspect has been
Not
dropped
a
by
single rupee is
68 compliance order
received.
saying that I will remove them. That was the report submitted by me.
No, one
The
thing,
compliance.
Lord, may I read 3 provision that will make very clear, my lord. 3 provision, only 3 provision, my lord. Section 64 may be seen first, my lord.
Yes.
For inquiry by registrar. The registrar may his own motion by himself or by a person authorized by him by an order in writing hold an inquiry into the matter specified in the order touching the constitution, working and financial condition of the cooperative society. Lord, this is enough, Lord. It's only 64 inquiry which is relating to only constitution, working and financial condition of the society. I will read 65, my lord. Lord, this is the nature of inquiry is different, and this is the nature of inquiry is different. Inspection of books of records of the society. Lord, here the inquiry, full-fledged inquiry will be done. But here the officer will go into the premises or he will call the original records, he will inspect into that, my lord. He cannot say that something which is covered under 64, it cannot be covered here. It's only whatever the original document in the hands of the society, that will be looked into and report will be submitted. I will read a 63, my lord. What is 63? My lord, kindly look at, these are the inquiries. Kindly 63, I may be permitted to read. Every cooperative society shall get its account audited at least once in a year before 1st September following closure of the cooperative year audit, or an auditing firm appointed by the auditor general body, cooperative society from panel of auditor or auditor firms approved by the directors of the, my lord, 63(1) mandates that the every cooperative society has to be done audit in every year, my lord. May I read 13, my lord, what it says? Subclause 13. If it appears to the state, my lord got that. If it is appears to the state on the application by an cooperative society or otherwise that it is necessary to expedient or re-audit the accounts of the society, the state government may by an order providing for such re-audit or the provision of the act, the rules applicable to the audit shall also apply to the such re-audit. My lord, this is a re-audit, my lord. Kindly what order passed in now, my lord, may I request 13 A capital A, my lord. 13 capital A. Notwithstanding anything contained these proceedings, subsection and director of cooperative audit, subject to the approval of the state government, shall have a power to re-examine and re-verify particulars. Re-examine and, my lord.
Now in the present case, 63(13)A.
13A. 13, my lord, which says that re-audit. It is not a re-audit. It's not an 64 inquiry. It is not an 65 inspection. It's only re-verification. What minds him? It is his original document. If he's done in a manner which is known to law, he doesn't have any apprehension for that.
No, we agree with you. Now only one point. From the, what is within the scope of 63(14)(13)A, you have a look at it. From now, what inquiry is ordered, you look at it because he's saying some of the items fall beyond 63.
Lord, even otherwise, Lord, may I request what my Lord saying, I will do that. Even otherwise, he cannot do that in this report because he's only seeing the re-examining, re-verifying the accounts he submitted. That is the limited purview under this.
Correct. So you take a stand, we'll observe that and say, now you can go ahead, subject to the limitation that your inquiry must be only with respect to re-examination of account or accounts of the audited accounts of the society and not into other matters beyond the scope of 13A.
No, the order itself is like that, my lord.
No,
13A, he cannot go beyond that at all.
Let us look at the order.
Lord, may I request,
Oh,
Lord,
that your lordship.
may I request, Lord, why these are allegations were there? 64 inquiry will be done, what they have submitted. What document they have submitted, the inquiry will be conducted and report will be submitted. It is a beyond that, my lord. Beyond that, whether he has submitted a originally audit report or there is any fishy in the audit report, that he will verify.
Independent inquiry.
Independent.
Correct, but he can't go beyond 63(13) capital A.
Huh.
That's all, we'll clarify.
That he will only re-verify and re-examine, that's it.
Now,
he cannot submit
now
a report at all.
If the inquiry now
A
is going to be
preliminary report had already been submitted stating that re-audit is not required.
So that we don't know.
Re-audit anta illa ಹೇಳ್ತಾ ಇರೋದು. Re-verification, re-examination.
13A.
But under 63(13)A, they can re-verify.
Your lordship may kindly take page number 149, annexure K. This was given by the joint director.
Now that we don't know. Finally, the decision that is taken under 13A is, it could be with the approval of the state government. So whoever officer may have taken, if the government decides otherwise, shall have the power to re-examine or re-verify. So subject to the limitations of 13A, let him go ahead.
Lordship may
They
kindly
can't
take
go beyond the power under 13A.
page number 165 for a moment. This is the inquiry report submitted by the joint director. Because he was directed to go to the society and with the preliminary.
That is for re-audit.
63(13)A, not re-audit.
160?
165.
Annexure K.
ಸಾಬೀತಾಗಿರುವ ಕ್ರಮಸಂಖ್ಯೆ ಮೂರನೇ ಆರೋಪವು ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣಗಳ ನಿರ್ಮಾಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ್ದು 2012-13 ಮತ್ತು ಅದಕ್ಕೂ ಹಿಂದಿನ ವರ್ಷಗಳಿಗೆ ಸಂಬಂಧಿಸಿರುತ್ತದೆ. ಆದರೆ ಈಗಾಗಲೇ 6-7 ವರ್ಷಗಳು ಕಳೆದಿದ್ದು ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ಕಲಾಂ 13A ನಂತೆ ಮರುಪರಿಶೀಲನೆಗೆ 5 ವರ್ಷಗಳ ಕಾಲ ಮಿತಿ ಇದ್ದು ಇದಕ್ಕೆ ಅರ್ಹವಾಗುವುದಿಲ್ಲ. ಮರುಪರಿಶೋಧನೆಗೆ ಒಳಪಡಿಸಲು ಯಾವುದೇ ಕಾಲಮಿತಿ ಇಲ್ಲದೆ ಇದ್ದರೂ ಸಹ ಆರೋಪಗಳ ಸ್ವರೂಪ ಮತ್ತು ತೀವ್ರತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸಂಘದ ಆರ್ಥಿಕ ತಕ್ತೆಗಳ ಮೇಲೆ ಲಾಭ ನಷ್ಟ ತಕ್ತೆ ಮೇಲೆ ಪ್ರತಿಕೂಲ ಪರಿಣಾಮ ಬೀರುವಂತಹ ಅಥವಾ ಕಾರ್ಯದರ್ಶಿ ಅಧ್ಯಕ್ಷ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರುಗಳಿಂದ ಹಣ ದುರುಪಯೋಗ ಮುಚ್ಚಿ ಹಾಕಲ್ಪಟ್ಟಿರುವ ಪ್ರಕರಣಗಳು ಕಂಡು ಬಂದಿಲ್ಲ ಕಾರಣ ಹಾಗೂ ದೋಷಪೂರಿತ ಲೆಕ್ಕ ದಟ್ ಈಸ್ ಫಾಲ್ಸ್ ಆಡಿಟ್ ದೋಷಪೂರಕ ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ಎಂದು ಪರಿಗಣಿಸಲ್ಪಡಬಹುದಾದ ತೀವ್ರ ಸ್ವರೂಪದ ನ್ಯೂನ್ಯತೆಗಳು ಇಲ್ಲದ ಕಾರಣ ಮರು ಲೆಕ್ಕ ಪರಿಶೋಧನೆಗೆ ಅರ್ಹ ಪ್ರಕರಣವಲ್ಲವೆಂದು ಅಭಿಪ್ರಾಯ ಪಡಬಹುದಾಗಿದೆ. This was by the Joint Director of Audit.
Now, where is the approval of the government?
The Lordships may kindly take Annexure L. Page 167. By this order, they appoint 168 is the relevant portion.
Now, have they referred to this report?
Which report, Your Lord?
Annexure K.
They don't refer it to.
ಅದು ಮರು ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ಬೇರೆ, ಪರಿಶೀಲನೆ ಬೇರೆ. ಪರಿಶೋಧನೆ re-audit, ಪರಿಶೀಲನೆ
Don't refer to this
re-examination.
report. The Lordships may kindly take page number 170 for a moment. In that there page number 170, Your Lordships. Annexure M.
Yes.
In that Ulleka 3, this report is referred to. ಸಹಕಾರ ಸಂಘಗಳ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ಅವರ ವರದಿ ದಿನಾಂಕ 10/6/2020.
No, but then they've considered it. The only thing we can say is we cannot enter into anything beyond the scope of 13A.
No,
and
that is
impose
not
such a restriction.
Lord, may I request, that is not at all necessary, because what is the power which is vest under 13 capital A, my lord? 63(13) capital A, he will do that only. He doesn't have that right to go beyond that, because it will hit by article this 64 report, my lord. Already there is a 64 report. He has filed in compliance report that is accepted, partly accepted, and there is only one allegation is not accepted, that is still open. That doesn't cover this. The object of inquiry under section 64 is a different, 65 inspection is a
Dispose it
different.
of clarifying
Oh.
that he has to restrict himself to 13 capital A with
Understand.
respect to audit of the accounts and cannot enter into other questions beyond the scope of this, including aspects of 64, as long as it is not linked with the audit report. And the
Lord,
I'll take instructions to that effect.
Lord,
and
even
please,
otherwise that is not required. Why? Because, my lord,
let us see. We will not interfere. We will only say
oblige.
that it must be accounts, audit reports, etc.
If he go beyond that, then he
So one
will
more
have a
lit-
right to
One
seek
more
for
litigation
quashing it.
we'll avoid, that's all. Relist the matter on
Thursday.
80.
Please. Interim order may be extended.
Interim order is extended till the next day.
Urgent 41. Harsha D 41.
Matter 6, another matter, your lordship, connected matter may be taken. 6538. Ravindra Prasad. Connected matter, your lordship, 6538 may be taken.
Yeah, for the respondent society, these matters were election, this one was, they were asked to file the notification with regard to the COVID.
Your lordship, last occasion I said to, your lordship has passed a similar order, your lordship, judgment.
Huh?
Similar matter has been disposed by your lordship. Your lordship has directed to produce that similar order.
Same society.
Minimum service, not similar, other society, your lordship. Minimum service, so for concern to the minimum service, your lordship, I have produced the material, your lordship, along with my memo, showing that majority of members have availed the minimum services. And so for concern to the, your lordship, attending the meeting, your lordship, there was a COVID, your lordship. In the COVID, when there is a COVID, your lordship, the exemption has to be considered, your lordship, at the time of COVID. And your lordship in similar matter has considered that exemption.
This matter,
In
the
page,
society is
7,
disputing the
Page 7, your lordship, is the
minimum
para
services,
6,
your
sir.
lordship.
No, correct. Now, insofar as attendance of general body meeting, what is the rule?
Three general body meetings.
Three general body.
Three general
Two-
body.
two,
meet-
your
Two. Now, after the amendment, it is two.
Two consecutive or what?
Two meetings.
Two
Only
meetings out of 5.
Two out of five.
Two out of last 5.
Last 5.
So now you have the records, isn't it?
Please.
You have the records.
Our stand is that they have not attended and the minimum services also is not availed. We are disputing it. So my submission, your lordships, on the earlier occasion, when these matters were coming before this honorable court earlier, for instance, HS Raju case and all, where 13D violations were all there. With regard to examining whether they have done it, whether they have availed the services or attended the meeting, a dispute should be filed, is what this honorable court. And my learned friend is well aware of it. In even the petitioner council is well aware of it.
No, now how many petitioners are there?
Your lordship, 70 petitioners are there, your lordship. Out
Now-
of 70, your lordship, 60 to 65 petitioners, your lordship, have availed the minimum services, for which I have produced the document, your lordship.
Right now,
memo.
if there are some of the petitioners who are ineligible, you say 5 or 6 of them.
Only one.
Are all of them eligible or there are some who are? not?
All of them are eligible, your lordship. These are the documents where it had been procured from the concerned authority to show that produce all those documents.
So you have produced.
Produced, whatever
Document
the-
to show all of them have availed services.
Please, your lordship, all of them. For a moment, your lordship, the memo may be taken.
So
Your
let's see, we'll accept it.
please.
Now insofar as meeting,
Your lordship, there is a COVID, your lordship, there is a exemption. And one more thing, your lordship. The notice 13D mandatorily has to be issued under your lordship through register post. There is no complaints of that. No complaints. For a moment, 13D may be taken, your lordship, to your lordship.
what is the total number of members?
Your lordship, total members 74 and
No, what is the strength of the total membership of the society?
41, and, 47 and 100 and
100 and?
170. 210, 207 euros.
207.
7, out of which 47 only eligible, sir. Other 170 members have been ineligible. It will not even comes to 25% of the members has been. 13D, your lordship, for a moment, your lordship. 2.
Now, where is your memo? Where's your memo?
Memo, your lordship, 18.3 to along with the documents, court officer. The memo is there.
No, but then what's the point in keeping this pending?
Your lordship.
Any, just, if anybody is aggrieved, let him raise a dispute.
Now, the question before this honorable court is whether the counts or whether the votes which they have cast should be counted or not, your lordships, because they are kept in a separate ballot. Now, since the society is disputing whether they have attended or not attended.
Correct. So availing services, he has produced a memo along with documents.
With regard to that, the society is disputing it, and 13D notice also we have produced. Yeah, I have filed a memo.
Now, insofar as the bank extract statement, you point out with respect to at least 4 or 5 of them who according to you are ineligible. Suppose you were to point out, then the whole thing goes. Because we cannot disagree.
Keep it for part.
So now, according to you, out of these petitioners, 4 or 5 people who are clearly ineligible, you point out.
Please, I'll do that exercise from.
We'll have it on Monday.
Tuesday.
Tuesday.
Expatia, I have produced the material.
Let us see. He's saying 4 or 5 at least he's going to show. Then we'll see what's going to.
On earlier occasions, what this honorable, such documents when they were produced, this honorable court was of the view whether this court can look into those documents or a section 70 election petition not to be filed.
Prima facie, if you were to show.
I'll look into.
Release the matter on 16. 16.
Please.
42. Serial number 42.
Pay for the respondent file.
Pay for hardship.
ನೋಡಿ 42 ಮಿಲಾಡ್
ಹಾ
ಅವ್ರು ನೆಸೆಸರಿನೇ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಕೊಡು.
He was the same order beneficiary in another case.
We'll pass over. At 2:30 we'll take it up. Pass over.
Yes, my lords, petitioner societies, the members of the respondent GCC Bank, Shivamogga. The respondent bank has prepared the list of, draft list of eligible voters, my lords. In that list, my lords, the petitioner societies were marketing societies. But the respondent bank has included the names of the petitioners in reason 3 and 4 instead of reason 2, the category of the list, my lords. For that, we have given the representation, my lords. Now the elections were postponed to 6th of June. But this is a stage of draft voters list, my lords. If my representation were considered, my lords, only
Who has to consider now?
respond 2 and 3, my lords. They are served, my lords, but not represented, my lords.
Who is this 2 and 3?
The bank managing director and chief executive officer of the
You
EDC.
find out. Can you see managing director Shivamogga DCC Bank? Any channel of communication? Can you intimate?
I will intimate.
Huh? We'll have it on Monday.
Oblige.
Monday.
Please.
He's only seeking for mandamus. He has filed objections.
Please.
Draft list is being prepared. He wants it to be considered.
Please.
We'll list the matter on 15.
Oblige.
Yes, what happened? Affidavit was required. Ready.
Copy ಕೊಡಿ sir.
We'll have it on Monday. Have a look at the affidavit.
Please, sir.
Affidavit filed, same is taken on record. This is the matter on Monday. Monday, get ready. I'm going to hear both sides and dispose it of either.
My lord, this
Serial number 18, my lords.
Madam is here, respondent.
I pray for time to file objections, your lordship. On serial number 18.
Transfer petition, isn't it?
Yes, your lordship.
What?
After vacation, your lordship.
Huh?
After vacation.
No. Transfer petition, this is a matrimonial dispute.
Please.
Matrimonial dispute, ಹೌದು but ಅವರು ಇಲ್ಲೇ work ಮಾಡ್ತಾ ಇದ್ದಾರೆ plus.
No, that's okay. No, after vacation. Transfer petition, I'm not going to hear it as some RFA or RSA. Whatever it is, you have to submit by the next
Immediately
day.
after vacation.
No,
your
no,
lordship.
no. I'm not going to give you so much time. 22nd, not a day beyond 22nd.
My
You have to
senior-
file your objection.
On that, your lordship, on that time, my senior is not.
No, you argue. You are sufficient. For this court, you are sufficient. You get instruction and you argue. You either file objection or make your oral submission. I am not going to give you time beyond 22nd. Relist the matter on 22nd. It's made clear that respondent will not be given further time beyond 22nd. Interim order earlier granted is extended till the next date.
Oblige.
My
lord, serial number 45. My lord, serial number 45.
Yes.
Have some personal inconvenience in the afternoon. There is a division bench matter, my lord.
Yes.
Some other date may take. I have informed Mr. Devi Prasad Shetty.
Yes. Bear date.
Well, serial number 17, my lord.
Shall we have it after, Somshekhar, shall we have it after vacation?
Yes, my lord. Please, my lord. Please, my lord. Please. Immediately after vacation.
This is the matter. Idyavdi. 45. This is the matter immediately after
Vacation. Much over.
Serial number 17, my lord.
46.
Serial, it's posted for 2:30, my lord. I
Ah.
have some emergency to travel to Kerala. My
Let
wife-
us see, let them argue. I'm still hearing the other side. Let them argue.
No,
Then I will take
There are two matters, 44 and 46. 46 arguments have yet not started.
No, correct, unless it's we'll see what,
That
I
is
will not,
elected matters.
I will not take up your matter till I complete that.
Okay.
That is still not completed.
So my interim,
Yes, yes,
please be this, I may please be excused to appear
Yes,
in the
yes.
afternoon.
I will not take up 46 till that is over.
Bless.
Yes,
Serial number
Rupesh.
17, my lord.
Huh?
230.
230.
230 ready.
Yes, yes.
ಅದು ಫೈಲ್ ಇಂಪೋರ್ಟ್ ಮಾಡಿ
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Court officer.
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ.
Court officer.
2:30 ಇದೆ ಸರ್ ನಿಮ್ದು. 2:30 ಇದೆ.
Court officer. Court officer.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ಹೇಳಿ.
Court officer.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ಹೇಳಿ ಸರ್.
Sir. Court officer.
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ. ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ಹೇಳಿ. ನೀವು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ನೋಡಿ ಸರ್, ಮ್ಯೂಟ್.
Court officer.
ಏನ್ ನಮ್ಗೆ ನೀವು ಹೋದಾಗ 11 ಇದ್ರು.
Court officer.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್, ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ. ಹೌದು ಮ್ಯೂಟ್ ಆಗಿದೆ.
79. Hello. Court officer ಕೇಳಿಸುತ್ತಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್, ತಗೊಳ್ತಾರೆ.
ಸರ್ ನಂದು ಐಟಮ್ ನಂಬರ್ 47 ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪ್ರಭಾ
ಬಂದ್ರು ಸಾಹೇಬ್ರು. ಸಾಹೇಬ್ರು ಬಂದ್ರು.
ಅದಿಷ್ಟಲ್ಲೇ. Pass over matters, serial number 16, Dilraj Rohit.
Relist on.
22. 22. Seventeen, Rupesh B.
Interim order event is extended to the next day.
16-4. Thirty-one. 31, Devi Prasad Shetty.
Lord, this matter regarding the appointment of nominated director, my lord.
Bonnet number 5. Lord, this matter.
ಇದೊಂದು ಕೊಡಿ.
Court of
31.
Court of sir.
So what are the facts of the present case?
Lord, facts of the present it, I will show to the extent of everything, my lord. The petitioner herein challenged the annexure appointing a nominated director, my lord. At page 29, annexure E, my lord. Serial number 1. Sri Jairam Reddy bin Chikkegodappa Linganhalli so appointed as a nominated director by the state, my lord.
Now what has been challenged?
Lord, annexure E,
Nomination.
item
Annexure E.
number 1, my lord, appointment of nominated director.
Under section 2018.
Adhikaretara.
Adhikaretara. Adhikaretara means non-official, my lord.
Non-official.
Non-official.
Not ex officio.
Not ex-official.
Non-official.
Non-official.
Yes.
He has challenged this on the ground that, my lord, the society is not an assisted society, one. There is no vacancy since the 13 is the bar of director should be there 13. So he cannot be appointed. The major ground is that the society is not a assisted society.
Yes.
My lord, may I request my lord to turn at page 26, my lord. He has produced the audit report, my lord. It is on his document, petitioner document. 26. ಲಗಿನಾಯಕನಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಸೋನ್ಸ ಅವರದ ಆಸ್ತಿ ತಕ್ತೆ. ಲಾರ್ಡ್ ಮೇ ರಿಕ್ವೆಸ್ಟ್ ಲಾರ್ಡ್ ಅಟ್ ಈ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಂತ ಇದೆ, ಅದರಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಈ ಐಟಮ್ ನಂಬರ್ ಕೊಡುಗೆಗಳು ಮತ್ತು ಸಹಾಯಧನ. ಲಾರ್ಡ್ ಕ್ಯಾನ್ ಸಿ ದಟ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಕಟ್ಟಡ ಸಹಾಯಧನ 50,000. ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಮೈ ಲಾರ್ಡ್. ಫಸ್ಟ್ ಈ 1 to 3 ಆದ್ಮೇಲೆ ಮತ್ತೆ 1 to 3 10 ವರೆಗೂ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, ಅಲ್ಲಿ 4 ಬರುತ್ತೆ. 4 ಆದ್ಮೇಲೆ ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 3
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಕಟ್ಟಡ ಸಹಾಯಧನ.
Obliged, Lord. Lord can raise a question to me that whether the Jilla Panchayat is a state or not. That Article 12, my Lord, it covers state. Local bodies. Article 12.
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್.
House. My Lord, petitioner can argue there is no vacancy. My Lord, may request at page 12, my Lord, annexure A. Annexure A. There is a 13 director, my Lord, that is the allocated ceiling limit that there should be 13 directors. Last item number 13, Khali. One post.
No, but that is reserved.
Reserved. May I request, my Lord? The same similar situation, whatever in that judgment also, even it is reserved, my lord, the certain villages doesn't have certain category people, my lord. Because of that reason, they are unable to elect to those posts. Because of that reason, those posts will be kept vacant. ಕೆಲವೊಂದರಲ್ಲಿ reserved post ಗೆ uncontested ಆಗಿ elect ಆಗ್ಬಿಡ್ತಾರೆ.
No, but from next time, what the government can do, they can say that this though was to be filled up by elected, as there's nobody from that category, it can be kept apart for government nominee. They can make one note and leave it at that.
Obliged. That, my lord, it has to be done earlier to election only. If my lord can see that up to serial number 7 in page 12, my lord, that is ಸಾಮಾನ್ಯ ಅಂತ ಇದೆ ಜನರಲ್, ಅದರಲ್ಲಿ ಅವ್ರು ಬರೀ actually election ಮಾಡೋದು 5ಕ್ಕೆ ಮಾತ್ರ ಮಾಡಬೇಕು, ಒಂದು post vacant ಇಡಬೇಕಿತ್ತು actually for the purpose of keeping vacant. But
what
the
is
post
the
which is
observation we have made in this?
No, para 8 and that.
Para
8.
That is insofar as grant. But
Not
number-
grant, no.
Number of posts?
Number of posts also it is there. in
Lord,
para-
it is in para 6. May I read, my lord?
Yes.
No doubt, the the terms of contention raised by the petitioners declare the elections were held for 13 posts. However, serial number 9 insofar as category for the scheduled tribe, same has been left vacant. Ideally, election should have been held only for the 12 post. One post should have been left vacant for the purpose of accommodating a government nominee. Though such is not in the case, in light of the peculiar facts of the case that where the post at serial number 9 is left vacant, the appointment of the government nominee does not result any exceeding of the limit under section 28A of the Act, where even if there are There are minor defects where there is no contravention of the law insofar as maximum number of directors of 13 as contemplated under section 28A of the Act. No ground is made out to exercise the judicial power under.
Yes.
And one more, my lord, I want to show that my learned friend is only appeared for the nominated director in this case. He was succeeded in the.
Yes, what do you say?
Lord, I could rely upon one judgment, my lord, now. Objections are filed. But when those,
Idalla.
Jilla Panchayat, if not Jilla Panchayat has contributed certain amount to the. But when it was given, no, that is not pointed out in the statement of objection.
No, ಇದಲ್ಲ ಅದಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮ್ಯಾಟರ್ ಇದು 49-17.
Oh, 49-71. Para 6-7 and or share capital in any form, my lord, that should be done.
No, where is the provision? It's not mandatory. Assistance need not be by subscribing to share capital. This was a case where share capital was involved.
Lord, kindly see this, Lord, ILR 2000.
No, what is the, let us have a look at the statutory provision.
Kindly see this judgment.
No, let us see what is the statutory provision.
A 4B1.
Paragraph?
What in this paragraph? Para 9, my lord. May I read, my lord?
Yes.
Para 9, as found earlier, admittedly, R2 is not an assisted society within the meaning of section 2A1 of the Act. And it was incompetent of the R1 state government to nominate any of its representative on the committee of R2 society because section 29(1) enabled nomination only in respect of assisted society. Nomination of R3 to R5 under Annex E was void ab initio. The said Annex E therefore did not cloth R3 to R5 with the membership of the committee of R2 society, but still they participated as such members in the election of the president held on 10/6/99, in which the first petitioner and the sixth respondent contested to the office of the president. As had been done in cases of being dealt with the division bench in the above said panchayat cases. If it had been possible to exclude the votes cast by the illegally nominated members in the said election or the office of the president and the declaration of the
But
results.
this is on a different point.
Not here, not it says that at some point of time, if the share is not, the government has given some share, but that cannot be counted for. Not if it is about 10 years back or 15 years back or 20 years back, some amount is given, but that cannot be constituted as a share amount, not that cannot be taken as assessed society.
Where is that? Where is that? Which is the rule?
No rule, this is not under 28A.
28A,
4B1.
Only says which has received assistance in the form of share capital
Yes.
or loan or grant or guarantee for repayment of loan or interest. Now, a grant from the government or state. If it's not defined, then it'll either go under General Clauses Act.
Lord, I have given one 1993 judgment, but ILA 1993 Karnataka, 2420, the first judgment. Now kindly see the head note itself, Lord. It is there in para 6, 7 and 9.
No, but here it was a question of share capital. But the provision doesn't say share capital. Share capital is one of it. Assistance in the form of share capital or loan or grant. So it can be either of it. Now here they say there's a grant from the
In this case, Lord,
Jilla Panchayat.
not the Jilla Panchayat, Lord, it is not, it cannot be called as a grant.
Why not? Government or state? It says which has
It will
received.
be directly by the state, Lord.
No, government or state. State will include Jilla Panchayat. Instead of the word government, by amendment in substitution in 2009, the word state is, the word government is substituted by government or state. Now look at the definition of state in General Clauses Act. There ends the matter. As long as it is a grant. If it's a grant by the state and state is defined and it includes a local body, there ends the matter. You see where the state is defined, we'll see it. That is the only point.
State, Lord, in this Cooperative Societies Act, Lord, is not defined.
So look at the General Clauses Act.
Be a separate wing, Lord, all this. Not all this panchayat, gram panchayat, it's a separate wing and it's in a.
No, let's see what the
Independent.
definition.
It's
It
an
only says
independent.
government, the word used was government earlier. Now it has been amended, substituted by government and state. So what do you define state? Where do you find the definition of state?
State
Have a
from-
look at it and
Lord,
then.
may I
we'll
read
see.
Article 12, Lord?
No, correct. But whether you can invoke, you have to go to General Clauses Act first to see if the word state is defined. Only on that point you verify, that's all. We'll see. Only on that point you verify, I'll have it on Monday, only on that point.
Please.
List the matter in the orders list on Monday. What is the definition of the word state?
Forty.
42?
42 also, Lord, maybe taken up Monday. Similar point.
Lord, in 42, the definition is not required because in 42, there is a reserved post for the nomination, Lord. Here, there is no nomination. It doesn't say that. The bylaw itself says in 42 that the society is assisted society. He did not choose to challenge that whether the society is assisted or not. Here, there is no doubt the society is assisted and there is a bylaw provision is made that the one post is kept vacant for the government nominee. May I show that?
Lord, on last occasion, kindly see annexure E, my Lord.
Annexure?
Annexure E. The Lordship had pointed out Adhikaretara Sadasanagi.
No, correct. So their interpretation.
Yes, interpretation of.
No, they're saying is non-official, not ex officio. Now annexure E,
Annexure,
is it ex officio or non-official?
Lord, it is no doubt it is not an ex officio. He is not an employee. He is not an official member.
Non-official.
He is only a non-official member. That is the word used for that. It is only for the purpose of non-official member. Lord, I have filed an statement, my lord.
Yes.
For that, I produced the annexure R1, my lord. That is the order made under section
So
12.
you tell me the facts.
Order. Election of the board was conducted on 21/1/2024.
21?
21/1, 2024.
Yes.
My lord, the government, the office bearer election was fixed on (15/11/2023).
Yes.
My lord, government 15, the government, my lord, as per annexure E, notified, my lord, nominating the respondent number 5 as the nominated director, Ashwatthama B. Same under section 28A 4B1. And in this, my lord, that's what it says. Karnataka Sahakara Sanghಗಳ ಅಧಿನಿಯಮ so and so ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಮಂಡಿಬ್ಯಾಡರನಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಮಂಡಿಬ್ಯಾಡರನಹಳ್ಳಿ ಕಸ್ಬಾ ಹೋಬಳಿ ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಇದರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಶ್ರೀ ಅಶ್ವತ್ಥನಾರಾಯಣ ಬಿನ್ ಬಚ್ಚೇಗೌಡ so and so ಕಸ್ಬಾ ಹೋಬಳಿ ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಇವರನ್ನು ಅಧಿಕಾರೇತರ ಸದಸ್ಯನಾಗಿ ಈ ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಸರ್ಕಾರದ ಮುಂದಿನ ಆದೇಶವರೆಗೆ ನಾಮನಿರ್ದೇಶನ ಮಾಡಿ ಆದೇಶಿಸಿದೆ.
He's not a government employee, isn't it?
He is not a government.
Not that the interpretation of adhikaretara is not whether not he can either he can contest or he can vote for the election.
No, that is only in case of ex officio. If he's not a government employee, he's not a ex officio.
He's not an ex officio, but whether or not he can contest,
That we'll see. That we'll see.
he cannot. Not he has filed the nomination paper.
That we'll see. Where is the? So now 28A 4B1.
4B1.
Now you are saying he has no right to contest.
Contest.
Take me to the provision.
But nomination say, but not.
The B, it says can also contest.
Also.
Nominated person can vote
And he can contest.
and also contest.
Except the ex officio member and someone who nominated by the creditors.
Primary.
Now, what is the
But
stand?
meaning, my lord, adhikaretara meaning, my lord, I don't know.
No, that we'll see. Yes. What is your stand in the statement?
Lord, stand in the statement that general meaning, dictionary meaning that adhikaretara means non-official. That is
And
one, my lord.
if he is ex officio, then he must be a government
Government
official.
servant. He
This
should be an assistant registrar
Correct.
or he.
Now here
deputy
he is a private person.
Private person,
Private person.
obliged not. He is a private person. And
What have you take? What is the stand taken in your statement?
Lord, me.
Lord, kindly see, my lord, one.
Para 4, my lord.
Para
4, my lord.
Lord, in the connected case, which my lord, lordship agent, nowhere, my lord, they have stated, even in that also, he is a private person. He is not a government official.
That's it. That's it.
ಅದ್ರಲ್ಲಿ ಎಲ್ಲೂ ಅಲ್ಲ ಎಲ್ಲ ನಾಮಿನೇಷನ್ ಎಲ್ಲೂ ಹೇಳೋದಿಲ್ಲ ಅಧಿಕಾರೇತರ ಅಂತ ಇದ್ರಲ್ಲಿ
That we'll see.
ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಹೇಳ್ತಾ ಇರೋದು ಅವರು.
That we'll ask them to file a memo. There ends the matter. Yes. Para 4.
Para 4, my lord. In the above side circum, the word used in the impugned order at Annexure E, Adhikaretara Sadasyaru, the said word used as non-official member, and it is also dictionary meaning is that non-official. Hence, the fifth response society was assisted by the state. Hence, the state has passed Annexure E by exercising power under section, sorry, my lord, it is 28 A4 B1.
Yes. And there is no restriction on him to contest.
No, no restriction. Only restriction on two persons, my lord. If he is an ex officio member, he is a government servant, he cannot contest election. If he is a government servant. If he is from the creditors, my lord, he is also from the bank. Like DCC bank will credit to the primary agriculture society, they will send his employee, he cannot able to contest. The normal member who has appointed as a nomination, he doesn't part any to contest and to vote. That is.
Now, the bylaw, where does it say assisted society?
My lord, my objection may be Annexure A, I will take.
R1.
And R1, my lord, that is the order passed under section 12, my lord, by the assistant registrar, amending the bylaw, my lord. He kept one post vacant for nominee, government nominee.
Yes.
And the subsequent, I have produced the subsequent bylaw at Annexure R2, my lord, at page 10.
Yes.
ಇಲ್ಲಿ ಕೈಯಿಂದ ಬರೆದ್ಬಿಟ್ಟು ಸಾಮಾನ್ಯ ವರ್ಗದ ಸ್ಥಾನಗಳು ಅಂತ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಕೆಳಗಡೆ ಒಂದು ಪೋಸ್ಟ್ ಸರ್ಕಾರದ ನಾಮಿನಿ ಅಂತ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಕೈಯಿಂದ ಆಗಿದ್ದು ಕರೆಕ್ಟೆಡ್ ಒನ್. ಅದಾದ್ಮೇಲೆ ಸ್ವಾಮಿ, I have produced the declaration of result of this year, my lord. The election result was declared on 28/2/24. That item number 11, my lord, ಖಾಲಿ ಇರುತ್ತದೆ ಸರ್ಕಾರದ ನಾಮಿನಿ.
Yes. But you file a memo, he's a private person. He's a private person, isn't he?
Lord, for that extent, he has to file because I cannot take a contention.
File a memo. English to Kannada. English to Kannada. The petitioner. Who is the elected director of the fourth respondent society has filed the present petition seeking for issuance of a writ in the nature of certiorari to set aside the notification issued at Annexure E, whereby the government has, by virtue of the power, has in exercise of the power under section 28 capital A 4B1 appointed Shri Ashwath Narayan. Respondent number 5. You appear. Respondent number 5.
Ashwath Narayan.
As within inverted comma, Adhikaretara Sadasya. We'll stop, close inverted comma. It is the case of the petitioner that there is ambiguity relating to the word Adhikaretara Sadasya while making appointment, comma, that nowhere it flows from the order that the fifth respondent is a private person, comma, that in the event the fifth respondent is an ex officio member, is an ex officio member, then such member is not eligible to contest as office bearer, and that needs to be clarified. Now you have contested also.
No, not contested, only voting.
It's filed nomination ansate.
No, yes.
Contest.
He has contested for the president.
Nomination.
Filed now, but his client has filed the nomination.
That election is still not done.
No, not declared.
Declared
declared.
because
Result
of
not
interim
declared.
order, my lord.
By
There
which
is an interim order.
Full stop. It is submitted that as the fifth respondent has filed nomination and participated in the election and seeks to be elected as
President.
president of the society. Unless he is a nominee director other than an ex officio nominee, he cannot be permitted to exercise rights of voting, rights of standing contesting.
Contesting.
In light of the same, counsel for the petitioner states that the order at annexure E being vague ought to be set aside. It is also contended that the society, next para, it's also contended the society is not an assisted society, comma, that nomination has been made with the condition that the fifth respondent will not contest. Next. Now, AG appearing for the respondent would submit that insofar as the submits that the society is an assisted society. And that would be made out from bylaw 56(3), which provides that as regards the board of management, government nominee has been demarcated as a separate category and one post is kept vacant. He submitted that such provision can be made only in case of assisted society, and once the bylaw provides for making of nomination without challenge to the same in the writ proceedings, court cannot traverse beyond provisions of the bylaw. Insofar as in support of the said contention, apart from relying on bylaw 56(3), government advocate also draws attention to the upaniyamagalu.
So, bylaw, it's a bylaw, my lord.
To the bylaws.
Bylaw number.
And in specific to bylaw 56(3), which reads as follows, page 10. Next. Further contended that the word adhikaretara sadasya refers to non-official member and does not refer to ex officio. And if he's a non-official member, in terms of 28A4B, the director is entitled not only to vote but also to contest. Full stop. Learned counsel appearing for the fifth respondent specifically submits that the fifth respondent is not a government servant and a private person, and files a memo to such effect. And accordingly it is submitted that there cannot be any restriction on his power to contest. Next. Heard both sides. At the outset, it must be noticed that insofar as the status of the society as being an assisted society, the bylaw itself provides for appointment of government nominee, and a post is kept aside for government nominee. This would be legally possible only if it is an assisted society. And once the bylaw provides for the same and same not being challenged, court cannot traverse beyond what the bylaw provides. Next. Insofar as the use of the term adhikaretara sadasya, it must be noticed that the fifth respondent has filed a memo and specifically states that the fifth respondent is a private person and not an ex officio member. An ex officio member refers to the definition of the term ex officio is inverted comma by virtue of one's position or status, which is the definition found in concise Oxford English Dictionary. In the present case, it is not in dispute that the fifth respondent is not a government officer. It's only government officers or officers of the Department of Cooperation who could be appointed as ex officio. The literal translation of the word adhikaretara is so and so. Accordingly, in the present case, it cannot be stated that the word adhikaretara refers to ex officio, but is taken to refer to non-official. If that were to be so, in terms of 28 capital A4 B1, the nominated person has the right to vote and contest. Next one. Insofar as the number of posts, it's clear that in terms of bylaw 56, there is a post that is set apart for government nominee. Accordingly, the nomination at annexure E must be deemed to be won by the government, and he being not an ex officio member is entitled to contest apart from voting. Order sheet. Accordingly, the challenge to the notification annexure E fails. Full stop. Insofar as the interim order passed, it is same stands discharged, and the respondents can proceed to announce results. Accordingly, petition is disposed of.
But in all other cases, my lord, they have not used this word.
ಇಲ್ಲ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅರ್ಲಿಯರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಯೂಸ್ ಸೇಮ್
No,
ವರ್ಡ್
that's okay. No, but
They have
now
just nominated, not
the
non-official.
you must file that memo.
They have not used this word.
earlier writ petition, my lord, that is here there is three members were appointed. I put in noted.
But he's not a government official.
No, not.
Next.
End of list matter.
Section 233.
Annexure G ink page 31 is a sale notice. My lord.
Annexure?
Annexure G ink page 31 is a sale notice. My lord. Reserve price bardilla. Sale is scheduled on Monday. My lord. Reserve price ಇಲ್ಲ. ತೀರ್ಪು ಮೊಬೈಲ್ಗೂ ಇದೆ 2 crore 17 lakhs.
44.
What is the date of
Sale, my lord.
sale?
Is on 15th, my lord. ink page 31 ಅಲ್ಲಿ fifth line ಅಲ್ಲಿ ಇದೆ. ಏಪ್ರಿಲ್ 15ರ ಸೋಮವಾರದಂದು.
How much you'll deposit, you say, then we'll see.
25% within a reasonable time.
You did not contest in the award.
No, my lord. Award, we are not disputing the liability. My lord. We are ready to pay. ಏನಂದ್ರೆ ಕಾಂಕ್ರೀಟ್ ಬ್ಲಾಕ್ಸ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇದ್ರು. ಹಸ್ಬೆಂಡ್ ತೀರೋದ್ರು. ಸೆಕ್ಯೂರಿಟಿ ಕೊಟ್ಟಿದ್ ಪ್ರಾಪರ್ಟಿ. Wife is about to get the amount what was the work order which is executed. My lord. Something which is related to the business. ಈಗ ನಮ್ಮ ಅಮೌಂಟ್ ವರ್ಕ್ ಆರ್ಡರ್ ಬರ್ಬೇಕಷ್ಟೇ, ಬರೋದ್ರೊಳಗಡೆ ಇವರು they have put it for auction. I'm not disputing any liability. I'm admitting the fact that I have availed the loan.
Vijay Mallya also raised the same defense.
No, my lord, I am available. Vijay Mallya is not available. I have mentioned in the
Subject
petition.
to-
Please.
Further consideration. There would be stay of the auction notice at annexure G and proceedings pursuant thereto, subject to the petitioner depositing the amount as contemplated for deposit under 105. 105. Such deposit to be made within a period of 4 weeks.
Please.
It's made clear that if deposit is not made, interim order would stand vacated without reference to the court. Full stop. The registry, taking note that a large number of matters, interim orders are passed at the instance of the borrowers. Registry to take steps to make a separate list of all matters relating to recovery where conditional stay is given and list the same to ensure, to find out if interim order conditions are complied with. AGA
And to
accepts notice, director accept notice, second respondent, emergent notice to the first respondent, list the matter 4 weeks admin immediate date.
Hand delivery.
Yes. 4 weeks. 27th.
Hand delivery.
Yes.
Great look. ಈ ಕೊಡ್ತೇನೆ ಮೆಮೊ.
Forty-four, Kempegowda, 44.
Other matters are not likely to reach. Ms. Manjunath, you can take another date. This is going to take some time. You can ask the court officer of your convenience. We'll have it at 2:30.
The last matter.
I'm also there, my lords.
Mr. Kulkarni, it will not reach today.
My lord, then it may be, my lord, after 24th or 25th.
May I make a mention, my lord?
Just 1 minute.
ನಮ್ಮ ಮ್ಯಾಟರ್ನಲ್ಲಿ ನಾನು ಈಗ ಈ ಸ್ಟೇಜ್ನೊಳಗೆ ನಾನು ಇನ್ನೂ ಹೆಚ್ಚಿಗೆ ಹೇಳೋದ್ರದ್ದೇನಿಲ್ಲ. ಅವ್ರೇನಾದ್ರು ಹೇಳಿದ ಮೇಲೆ ಐ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು.
ಅವ್ರು ಶುರು ಮಾಡಿದ್ರೆ ಬಿಡಲ್ಲ.
ಅವ್ರು ಶುರು ಮಾಡಿದ್ರೆ ಮಾಡೋದಾದ್ರೆ ಅಡ್ಡಿ ಇಲ್ಲ, ಅದಲ್ಲದೆ ಹೋದ್ರೆ.
You're ready, is it?
I'm ready.
Ms. Kulkarni some other day.
On 25th, my lord.
Yes. Relist.
If it is
One?
serial,
Just one. 25th.
Yes, madam.
if it is serial number 46, my lord, there is an interim order, it will be extended.
The interim order may be continued, my lord.
Yes, yes. Kulkarni or matter interim order earlier. Granted is extended till the next day.
46 is the difference.
46 wait at the end will give it. You appear on behalf of?
R3.
That is?
Number 47 to 18.
Who are you?
I am the cooperative society, my lord. R1 is the deputy registrar and R2 is the assistant registrar who registered the cooperative society. It is a cooperative society of the allottees of the apartment complex built by petitioner number 1. Petitioner is the promoter of that
Acts good.
Petitioner is the promoter of that apartment complex. In the writ petition, my lord, the prayer is the petitioner has sought for order or direction for quashing annexure A, which is which is an order against the appeal filed by the petitioner, my lord, in which they challenged they sought for cancelling the registration of the cooperative society. My lord, this project is a post-RERA project. It is a project registered under RERA. It is not registered as an ongoing project, but as a project which was registered with full validity of the RERA provisions. Under the RERA, my lord, the RERA rules defines association of allottees. Association of allottees means a collective of allottees.
Association of?
Allottees. Rule 2B, my lord, of RERA. In the definitions, B, 2B, my lord.
Rule.
RERA rules, my lord.
Yes.
Rule definition 2B, my lord.
RERA rules.
Yes, ma'am.
2017 it is, rules of Karnataka rules.
2D.
Association of allottees, the lordship gets it.
2B.
Two Bs.
Yes.
Association of allottees means a collective of allottees of a real estate project by whatever name called, registered under any law for the time being in force, acting as a group to serve the cause of its members, and shall include authorized representative of the allottees. I emphasize whatever name called, registered. And 2C, same my lord, 2C is, it defines cooperative society.
Yes.
2C is, it defines cooperative society. Cooperative society means a society registered or deemed to be registered under Karnataka Cooperative Societies Act 1959, Karnataka Act number 11 of 1959. Here that deemed refers to, my lord, a society when an application is made by minimum number of promoters required. In this case, it is a 20 members. The 20 members once file an application, and within 3 months, if the officials concerned does not reject or approve that, that society will be deemed registered.
Under the
Under Cooperative Societies Act 1959, section, my lord, 7, registration 4. Section 5, registration with the limited society which may be registered, where an applications of individuals, the number of applicants shall not be less than 20, and the applicant 13 days. Okay, application shall be accompanied by 3 copies. I'll take your lordship there, my lord.
Seven two.
My lord.
7-2.
Yes, yes. Yeah. 7-2, my lord. If the registrar is unable to dispose of such application within a period of specified in subsection 1, the society and the bylaw shall be deemed to have been registered. So an appeal was filed, my lord, under section.
Now this overrules everything else. RERA Act.
Which one, my lord?
RERA.
RERA, yes. I will take your lordship there because there is a recent judgment of the Supreme Court also, which gives goes in detail to explain section 88 and 89 of RERA Act, where it says that it overrules. I mean, it is. I'll read out that. So that is, the Honorable Supreme Court has gone into very detail in the judgment passed against while repealing, while quashing, I mean, setting aside the legislation itself, man. West Bengal government brought in a legislation, which in fact, in the language of the Supreme Court, it is a parallel regime. After the RERA, in list 2, they enacted Housing Industries Regulation Act, West Bengal's HIRA, Housing Industries Regulation Act.
while setting aside, while quashing the legislation itself, the Honorable Supreme Court referred to specifically Karnataka, this COFA Act, what they call it as Karnataka Flats Act, Regulation Act, where it has specifically emphasized on section 88 and 89 of RERA, application of other laws not bar. The provision of this act shall be in addition to and not in derogation of the provision of other law for the time being in force. The act to have, 89 says, the act to have overriding effect, the provision of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So this has gone in very detailed, my lord. That judgment I'll be placing before your lordship, which has all the details. I'll fill the memo, I'll file it, my lord. So, my lord, this. I'll file it in a memo later, my lord. Your lordship can refer to that.
Yes, let us see. Yes.
That will be placed when. So, my lord, here the petition, this petition, my lord, is under, the prayer is for order or direction quashing of the order of Annexure A, dated 7/2/2024, passed by first respondent. And the second prayer is for quashing, cancelling the registration granted by the respondent number 2 to the respondent number 3 society, my lord. The first Annexure A was, my lord, it rejected the appeal, which was filed under section 106, 1A and 2A of Karnataka Cooperative Societies Act. My lord, 106 of the appeal to the others. And 1A is an order of the register under section 7.
Appeal against which order?
Registration, ma'am. Under section 7, the registration. They are challenged the registration by by R2 is being challenged by a promoter, ma'am.
They challenged it first before?
Before R1. By an appeal. Appeal under 106(1). A and 2C.
So directly they went under 105, is it?
106, 1A and 2A.
One A and
2A, my lord. An appeal against an act, decision or order under subsection 1 shall be made within 60 days. If the act or decision or order may be. So, my lord, formation of a cooperative society or any kind of an association is very much permissible for me under the RERA. And moreover, cooperative society formation, a cooperative movement, any cooperative society, this is my fundamental right under Article 19C of the Indian Constitution. To form associations or unions or cooperative societies. My fundamental right, my lord, as well as 43B, my lord, state legislative policy. The promotion of cooperative societies. The state as a duty, in fact, my lord, the state shall endeavor to promote voluntary formations, autonomous function, democratic control, and professional management of cooperative societies.
You're reading?
Constitution 43B, my lord. In 19C, it is my fundamental right, my lord. And 43B, the state's responsibilities.
Yes.
And my lord, there is a further regarding the cooperative societies. The constitution has much more into that, my lord. Anyway, lordship. So, formation of a cooperative society is my fundamental right. And the cause is allowed as it is a RERA project. The cause for which, the purpose for which I have made it is permissible under RERA. So this challenge to that extent does not survive. Even otherwise in the writ petition in second prayer, they're asking for the quashing of this registration on certain other grounds, which I'll take your lordship through RERA, my lord, because this is admittedly a RERA project, and my lord, the RERA is a legislation. My lord, the central government enacted under list 3, the concurrent list, my lord. As a bill, my lord, in 2013 when it was introduced, a standing committee on urban development, my lord, was constituted, a 21-member committee. This committee, my lord, had conducted sittings in various cities, including Bangalore, I emphasize. The reason is the rejoinder of the petitioners. In the rejoinder, the petitioner has taken a contrary view, which contradicts the RERA section 17, which I'll take your lordship later on. But I emphasize that this standing committee, which is the Standing Committee to Urban Development, which submitted the report. I've placed that report also before the court. They conducted various sittings. And this is all part of the Supreme Court's judgment also, my lord, in the Forum for People's Collective Efforts versus the state of West Bengal. The same judgment I'll place it before. My lord, this committee, in its sitting, it had come to Bangalore. It had taken opinion from the public, all kinds of stakeholders. They had conducted the sittings. And if there existed any special situation in Bangalore, as far as the real estate activities are concerned, this standing committee is aware of that. And legislators could have, in fact, if they wanted a separate, a different view on that, that would have been come as their opinion, my lord. I emphasize on that this committee specifically took opinions from the stakeholders in Bangalore too. The act, my lord, emphasized, particularly, my lord, because as early as in 1970s itself, Karnataka had its legislation, various states had its local legislations with respect to the real estate activities, my lord. Karnataka had the Karnataka Apartment Ownership, Karnataka Flats Act first, and so another following act immediately, Act number 16 was the Flats Act, and 17 is the Karnataka Apartment Ownership. The reason is very much within that. The objective itself clarifies it. All the states had its legislations, but center felt it, the legislators felt it is not enough, and specifically because the center wanted that the symmetry of information, particularly on 4 points the legislation was made, the symmetry of information between the promoters and purchasers, the transparency of contractual conditions, threshold standards and standardization of accounting. The legislators intended to have a standardization because, my lord, the real estate sector is the second largest employment generator after agriculture, in spite of which there was no regulatory body all over. And as such, in the concurrent list, the center goes and the RERA as a code, my lord, it has been announced, which covered everything, which gives all kinds of services. And the other local acts is in addition and not in derogation of this act. That has overriding effect to the extent which has a repugnancy, which is inconsistent, is void. Legislative intention was also to fast track dispute resolutions and mechanism. This legislation, my lord, is one that is of preventive in nature rather than curative. Unlike the Consumer Protection Act, which is curative in nature, RERA is a preventive legislation. This is more emphasized because, my lord, any possible mischief has to be prevented. My lord, that is very clear in the objective. Possible mischief against whom is very clear. The act in its objectives, my lord, RERA, read the objectives of that itself. An act to establish the real estate regulatory authority. An act to establish the real estate regulatory authority for regulation and promotion of the real estate sector and to ensure sale of plot, apartment of buildings, as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear appeals from the decisions and directions or orders of the real estate regulatory authority, and the adjudicating officer and the matters connected therewith or incidental thereto, and 79 bars jurisdiction for other courts. The important few definitions are of primary relevance.
79?
79 bars jurisdiction. Before, I'm coming there, my lord, before to that. Bar of jurisdiction 79, section 17. It functions as an exclusive. No civil court shall have jurisdiction to entertain any suit or proceedings in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. Even the criminals, it's 89, cognizance of an offense. No court shall take cognizance of an offense punishable under this act or rules or regulations made thereunder, save on a complaint in writing made by the authority.
Section?
80, man, 79, next 80. Chapter 10, man. I was reading 79, yes. 80. 80 is cognizance of an offense. No court shall take cognizance of any offense punishable under this act or rules or regulations made thereunder, save on a complaint in writing made by the authority, that is the RERA authority, or by any officer of the authority duly authorized by it for this purpose. No court inferior to that of the metropolitan magistrate or judicial magistrate of the first class shall try any offence punishable under this act. My lord, I beg your lordship to come back to the definitions, my lord, because I emphasize on certain definitions here. RERA defines allotment. Section 2D, man. Immediately after the objectives, my lord. Definitions 2D. Yes. Allottee in relation to a real estate project means the person to whom a plot, apartment or building, as the case may be, has been allotted, sold, whether as a freehold or leasehold or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, is given on rent. So allottee is not a person, my lord. Allottee includes even a person who gets an allotment. Just a booking form makes him eligible for him to become an allottee. Apartment, the next definition, my lord.
Allotted, sold, either first or subsequent.
Yes, yes. That's the entire thing, man. Agreement holders from the booking till the sales or subsequent sale is also an allotment. I emphasize on that for the reason I will take your lordship in later part, because, my lord, there is certain legislative intention on, and there is some inconsistency in the local laws which exclude certain persons. The second definition, man, the C is apartment. Man. This also of great relevance, my lord, because here the apartment is defined under RERA, whether called block, chamber, dwelling unit, flat, office, showroom, my lord, here, unit, flat, office, showroom, shop, go down premises, suite, tenement unit, or by any other name, means a separate and self-contained part of an immovable property, including one or more rooms or enclosed space located on one or more floors or any part thereof in the building, or a plot of land used or intended to be used for a residential or commercial use, such as residence, office, shop, showroom, or go down, or for carrying on any business, occupation, profession, or trade, or for any other type of use ancillary to the purpose specified. I emphasize on this is, my lord, the residential or commercial, because there is a inconsistency in the local act, and that has been emphasized by the petitioner in the arguments, my lord. And there is a clear legislative intention which is being narrated in the report of the committee also. Why there was an inculcation of not only limiting to residential, but why there was the commercial and industrial is also included. The next definition I want to read, my lord, is J, building. Building, any structure or erection or part of a structure or erection which is intended to be used for residential, commercial, or for the purpose of any business, occupation, profession, or trade, or for any other related purposes. My lord, then the next definition I want your lordship to be taken into. P, my lord, it defines competent authority. Competent authority for this. Competent authority means the local authority or any authority created or established under any law for the time being in force by the appropriate government which exercises authority over land under its jurisdiction and has powers to give permission for development of such immovable property. Here, my lord, the sanction plan, sanction and everything related to the development, most of the things are granted by the local authority. The competent authority for sanctioning and things have been defined there. Then, my lord, the definition on ZK, my lord. And ZG is a person, my lord. In person, a cooperative society is also defined. ZG 7. Definition ZG person includes. In that, my lord, 7. Roman 7. A cooperative society registered under any law relating to cooperative society. Your lordship gets it. ZG. Person, under definition, person. Person includes for RERA. And my lord, the next definition is ZK promoter. ZK man. Promoter means a person who constructs or causes to be constructed an independent building or a building consisting of apartments or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to other persons and includes his assignees or a person who develops land into a project, whether or not a person also constructs structures on any of the plots for the purpose of selling to other persons all or some of the plots in the said project, whether with or without structures thereon. Any development authority or any other public body in the respect of allottees of a building or apartments, as the case may be, constructed by such authority or body on the lands owned by them or placed at their disposal by the government, or plots owned by such authority or body or placed at their disposal by the government for the purpose of selling all or some of the apartments or plots, an apex state level cooperative housing finance society and a primary cooperative housing society which constructs apartments or buildings for its members or in respect of the allottees of such apartments or buildings, or any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or any other name, or by any other name, or claims to be acting as a holder of a power of attorney from the owner of the land on which the building or apartment is constructed or plot is developed for sale, or such other person who constructs any building or apartment for sale or to the general public. My lord, here the promoter, my lord, in the promoters, the landlord, my lord, is a principal promoter. In fact, that has been defined in a order by the NCDRC, my lord, the National Consumer Forum, my lord, where the liability of the landlord is joint and several, my lord. Is primarily the landlord becomes the principal in the transaction, and in fact the builder is their agent. So the promoters, they are not allottees. The landlord cannot become an allottee under no circumstances as per RERA. So an allottees association specifically excludes inclusion of promoter as a member. Just, I mean, because he may own some of the apartments. That will undermine the RERA intent. Because allottees association does not include promoter in it. Promoter cannot be called as an allottee. Association is allottees association. My lord, RERA section 8, my lord. Next important provision for my.
So, the word allottee excludes promoter.
Excludes promoter specifically, and there is a reason for that. Because allottees association cannot include, or if there is a provision under local law, local enactment, which allows so that by application of section 88 and 89, my lord, becomes void and it becomes repugnant, my lord. 254 applies.
Now, in case under the sharing agreement,
My lord.
flats are allotted to the owner, X
Yes,
number of
yes,
flats.
yes.
Now, he will not come under the, according to.
It should not come. If it comes, there are not only one consequence, especially that is why I emphasize, my lord, it is a preventive legislation. So if a landlord has, generally it is 40-60 or sometimes 50-50. And the allottees association has already a 40 member who is at one side, and the allottees interest will be subdued. Allottees definitely cannot have their voice, the say in the any kind of an association for that. And that is what happening in every associations who emphasize that a deed of declaration will give right to a deemed society, deemed association, which there was no such legislative intent, and RERA, if at all it was there, it has overruled everything. I will come to your lordship, take your lordship there in a detailed manner. Lordship may kindly go to section 8, man.
Section 8.
8, sorry. Obligation of authority consequent upon lapse of or revocation of registration. May I read? Upon lapse of the registration or on revocation of the registration under this act, the authority may consult the appropriate government to take such action as it may deem fit, including the carrying out of the remaining development works by a competent authority, or by the association of allottees, or in any other manner as may be determined by the authority, provided that no direction, decision, or order of the authority under this section shall take effect until the expiry of the period of appeal provided under the provisions of this. Provided further that in case of revocation of registration of the project under this act, the association of allottees shall have the first right of refusal for carrying out of the remaining development works. My lord, I emphasize on this section is, this gives a vast power. Even section 7 gives authority an extensive power where it can take any kind of a decisions in the interest of allottees for the completion of the project. Because, my lord, the completion of the project will help all the stakeholders. It will be more helpful for the promoter. It will be more helpful for the financiers there. It will be helpful for the society and primarily the allottees. So why I am emphasizing here, my lord? These associations are required to be formed prior to the allottees becoming the owners. Allottees associations requirement is prior to the allottees are registered with their property as owners. So the local act, Karnataka Apartment Ownership Act, confines the association membership to only the owners. And this will take effect only after the project is completed.
Karnataka,
Apartment Ownership Act 1972, my lord, in which the petitioners are claimed to have formed an association.
this according to you is an association only of owners.
That is only of owners. It can only, the associations, it is association of owners alone. There is no definition for allottees there. My lord, the next section, my lord, is in chapter 3, the functions and duties of the promoter. In by. Section 11. Functions and duties of the promoter. My lord, here, the promoter shall, my lord, I'll read B, my lord. Quarterly update. Quarterly up to date the list of numbers and types of apartment or plots as the case may be booked. My lord, the RERA in its portal, in its website, my lord, the promoter has to create a, on the registration, my lord, they are given a portal. There's a dashboard for them. I mean, it has to be uploaded. The intention, my lord, it should be completely transparent. Allottees and the public should be aware of what is that there in the project. They will be given a login ID and password where things are to be updated. And there should be a quarterly update where the promoters are mandated as to publish the number of persons who have booked it. This has a particular purpose, which is admittedly violated by the petition. C, my.
Yes.
Quarterly update the list of number of garages booked. So plots, everything that booked should be public. They cannot keep it as a secret. And it is not done by majority of the builders because they don't want to reveal the number of bookings happened, maybe for the purpose of marketing or because there are some mischievous intent also, which includes mortgaging the property, which is prohibited here, which is not permitted, which is there. In this case, the promoter has mortgaged the property subsequent to the sales that has happened, in direct violation of the RERA provisions. I read the 11(4), the promoter shall.
Anyhow, those are separate battles you are fighting.
My lord?
Those are separate battles. Mortgage, etc. Here we're.
Yes. No. The problem is, the issue is, my lord, the cooperative society is formed with a specific purpose, which as I told my lord, as the legislators intended, it was curative in nature. I mean, it is a preventive in nature. The promoters found that several practices that was done by the petitioner, even though it is among the top builders, it was not as per the RERA regulations or as per required. It was detrimental to the interest of the builder. I mean, the allottees. The reason, one of the primarily, my lord, I should bring to the notice of this court is, my lord, this is strangely the petitioner, my lord, when RERA specifically prohibits accepting more than 10% of the sale consideration without registering the agreement of sale. 100% of the amount is taken in advance. Even the last stance, the last installment is also taken 1 year in advance before the registration without a registered agreement of sale. And thereafter, certain documents are registered without that being shared with the allotment. And also, the sale deed, the agreement is unregistered and the sale deed is registered with where the consideration of the entire amount consideration is not shown in it. For example, my lord, one of my members consideration amount for the villa for the apartment is 2 crore 30 lakhs, 36 lakhs rupees. When it is 2 crore 36 lakhs rupees, his sale deed shows the consideration price as 56 lakhs or 76 lakhs somewhere as the land cost, and the balance amount is received as per the agreement of sale. And this agreement of sale, my lord, is unregistered. Where if tomorrow I have to sell the plot, my lord, and I'm selling it at under price. I say sell it at 2 crore itself, but at a 30 lakh loss. But my capital gains is shown as a huge amount. I have to carry this unregistered agreement to establish whether there was no capital gain. In fact, it is a loss. And this on a long term, where even the deed of declaration, which under Karnataka Apartment Ownership Act itself says that the deed of declaration should contain the value of the property, it is systematically excluded. The deed of declaration is filed, registered, without it being shared by without it having the allottees have an opportunity to look into that. That becomes a registered document. Even that also doesn't contain the value. The sale consideration nowhere there. These were the things which was brought to the notice of the promoter. And when that was gone completely ignored, the allottees was forced to make this cooperative society. And that too, as per the RERA itself. They did not go and conduct something which is different. Here, the petitioners, my lord, in fact, they complied with the RERA provisions as far as enabling. And these society members became the members there as the enabling part of that. And they, as required under that, they registered the cooperative society. This is what happened. So, my lord, here each and every provisions which I am reading out, my lord, there is a specific legislative intention why that was included there. And that countermines many of the provisions of the local act, which cannot be applied when it is a RERA project. That is my emphasis. We'll find. My lord, your lordship may kindly go to 11.4, the promoter shall. The promoter shall be responsible for all obligations, responsibilities and functions under the provisions of this act or the rules and regulations made thereunder of the allottees as per the agreement of sale or to the association of allottees. My lord, there is a specific reference that to the association of allottees, as the case may be, till the conveyance of the apartments, plots or the building, as the case may be, to the allottees or the common areas to the association of allottees. My lord, conveyance to the association of allottees or the competent authority as the case. The competent authority here when it is a housing board of I'm reading this, my lord. The rejoinder of the petitioner totally contradicts this. It is an admitted violation of that requirement under the RERA. 4B, my lord. Be responsible to obtain the completion certificate or the occupancy certificate or both as applicable from the relevant competent authority as per local laws. And this competent authority is, my lord, the sanctioning authority. As per local laws or other laws for the time being in force and to make it available to the allottees individually or to the association of allottees as the case may be. C, be responsible to obtain the lease certificate where the real estate project is developed or on leasehold land or specifying the period of lease and certifying that all dues and charges in regard to the leasehold land has been paid and to make the lease certificate available to the association of allottees. There also the association of allottees has a serious role. D, my lord, be responsible for providing and maintaining the essential services on reasonable charges till the taking over of the maintenance of the project by the association of allottees. In all the cases, my lord, here, the maintenance is always done by the promoter for certain period for which they take advance amount. The allottees are charged with an advance amount. In this case, each apartment was charged 5 lakh rupees. Around 19 crore plus, 19 crore 70 lakhs, around 20 crore rupees is in the hands of allottees under a specific condition, my lord, that this will be a corpus fund, kind of a corpus fund, where the interest will be used for maintenance activity. And there is a serious violation of this particular undertaking, my lord, the agreement terms, specific agreement terms regarding this corpus fund is being violated after filing of this case. I'll bring it on record before this court. D, my lord, be responsible for providing and maintaining the essential services. Yeah, E, my lord, enable the, this is very important. I emphasize on this, my lord. 11(4)(e), my lord, enable the formation of an association or society or cooperative society, as the case may be, of the allottees, or a federation of the same under the laws applicable. My lord, here, this particular activity, my lord, formation of an association, formation of a society, my lord, the Parliament did not interfere with the state's prerogative on it, because formation of a cooperative society comes under the second list, my lord, which is state exclusive, where a center cannot, in fact, take a. And this is not available in the concurrent list. If an association, if as claimed, the Karnataka Apartment Ownership Act, which admittedly, my lord, is legislated under concurrent list, because both the Flats Act and the Apartment Ownership Act, it is under list 6 and 7 of the third list, my lord, entry 6 and 7 of the third list, where it is transfer of property and things and all, and it is not under state list exclusively, because it was, my lord, with the precedent tax. It is a concurrent list legislation, and RERA being a concurrent list by the Parliament, which has an overriding, admittedly, there is, if anything else, that the Article 254 applies, that will be repugnant to the Constitution.
Just what is the proviso saying?
Which one, Mal?
4E proviso.
Provided that in the absence of local laws, the association, this is where, provided that in the absence of local laws, the association of allottees by whatever name called shall be formed within a period of 3 months to the 3 months of the majority of allottees having booked their plot or apartment or building, as the case may be, in the project. I emphasize on this. There is a law which is very much consistent with this particular provision, enabling. It is Karnataka Flats Act, Section 10 of Apartment Flats Act. I'll take your lordship in that when I'm going through that act particularly. The consistency, my lord, from the objectives, from the definitions of each terms and each provisions, is the Karnataka Flats Act, which has been completely ignored, and never been followed by any promoters. is the Karnataka flats. And that is, in fact, totally consistent with RERA. And where there is a specific provision regarding formation of cooperative society. I'll take your lordship there, section wise on. My lord, the next provision in this. So here, my lord, it is when there is a local law which is consistent with RERA, that will apply. And that law is Karnataka Flats Act. Section 10 specifies for formation of a cooperative. I'll read it for the 10. The Karnataka Flats Act promote section 10, my lord.
Just 1 minute.
Yeah. It is Karnataka ownership of flats, regulation of the promotion, construction, sale, management, and transfer of it.
So this is acronym is COFA.
They call it as COFA. Other one is KAOA.
This is the earlier act, is it?
Yeah, this is the first act, with Act number 16 and Karnataka Apartment Ownership Act, Act number 17. I'll take your lordship on detail on each sections on that. Just section 10 itself, my lord, because that has a direct bearing on 11E. The promoter.
Section
10, my lord, that COFA.
law should be simplified. You can't keep on making it more complicated.
My lord, here, when the RERA was enacted, my lord, by section 92 of RERA, the Maharashtra's an act was repealed. The Kerala thereafter, the state itself repealed that. And my lord, Supreme Court, the West Bengal subsequent legislation was passed when it was, and in that matter, the Supreme Court has made a specific reference to this act, where it says that the provisions of the act which is consistent will retain, and the others will be void. There is a specifically this act has been referred there, and an observation is made by the Supreme Court. This is a very small act, my lord, with some 18-19 sections, and which is an obligation of the promoters, which in fact should have been acted as a RERA, which would have been, in fact, if it was implemented in the right manner, my lord, there would not have been a requirement to, in fact, enacting the RERA itself. I'll read the section, my lord. The promoter to take steps for formation of cooperative society or company. My lord, the 11E and the 11E of the RERA and 10, the consistency may be looked into, my lord. 11E reads, enable the formation of an association or society or cooperative society, as the case may be, of the allottees or a federation of the same under the law applicable. And section 10, my lord, the promoter to take steps for formation of the cooperative society or company as soon as the minimum number of persons required to form a cooperative society or a company have taken flats, the promoter shall, within the period prescribed, submit an application to the registrar for registration of the organization of persons who take the flats, and as a cooperative society, or as the case may be, as a company, and the promoter shall join in respect of flats which have not taken in such application for membership of cooperative society, as the case may be, of a company. The last part has an inconsistency, but the first part, my lord, is totally is consistent with the 11(4)E of RERA.
Yes.
11F, my lord, of RERA. May I please go back to. execute a registered conveyance deed of the apartment, plot or building, as the case may be, in favor of the allottee, along with undivided
You're reading
proportionate.
section?
My lord, 11(4)(e), my lord, EF, my lord. I'm reading F. Immediately after E, my lord, which I read earlier. May I please?
Yes.
Execute a registered conveyance deed of the apartment, plot or building, as the case may be, in favor of the allottee, along with the undivided proportionate title in the common areas to the association of allottees. The undivided proportionate title in the common areas to the association of allottees or competent authority, as the case may be, as provided under section 17 of this act. My lord, here the common area is required to be conveyed to the association of allottees. Specifically, when the legislative intent of RERA was to standardize all over the country the modalities in which the conveyance of real estate property has to happen, there cannot be a contradictory view, man, in a self-serving definitions. It is very clear because it has been spelled out clearly, and there cannot be a escape route for that, for the petitioners to, because that has been admittedly denied by the petitioner, that cannot be done. It is not required to be done, is what their language. In their rejoinder, it has been. Pay all outgoing, G, my lord, F, after F, G. Pay all outgoing until the transfer of physical possession of the real estate project to the allottees or the association of allottees, as the case may be, which has collected from the allottees for the payment of outgoings, including land cost, ground rent, municipal or other local taxes, charges, or whatever, or for water or electricity, maintenance charges, including mortgage loan and interest on the mortgages or other encumbrances, and such other liabilities payable to the competent authorities, banks and financial institutions which are related to the project. And my lord, H, my lord, this is again, my lord, G and H I am reading because, my lord, here there is a direct violation of this by the promoters. H, my lord, after he, the promoter, executes an agreement for sale for an apartment, plot or building, as the case may be, not mortgage or create a charge on such apartment, plot or building, as the case may be, and if any such mortgage or charge is made or created, then notwithstanding anything contained in any other law for the time being in force, it shall not affect the right and interest of the allottee who has taken or agreed to take such apartments, plot or building, as the case may be. Here, I'm not saying that they cannot mortgage, let them mortgage, but the requirement is, my lord, if there is a detail of the bookings, if there is a detail of the registered agreement, if the agreements are registered, the mortgagee will be aware that what is the amount, extent of sale has happened, what is the extent of encumbrances already, charge already is created. Maybe not the petitioner, my lord, who has cleared that mortgage, of course, but this is what is happening with all the promoters, that they take the mortgage and for some reasons they fail to do that. And the financial institution take over the property at its entirety, because the property is always mortgaged at its entirety. And the option left to the allottees is to approach the DRT. And DRT will first ask the question whether your agreement is registered or not. When it is dictated by the petitioner, dictates that agreements will not be registered, the allottees have no choice, and the RERA's intent to protect the interest of the consumers does fail here. And this, admittedly, not even one agreement is registered. My lord, section 13, my lord.
Section
13. Only few more sections, my lord.
We'll continue.
Oh, my lord. Excluding 16th and 18th. Any day.
This one. I'll send it to you.
22nd at 2:30.
22nd, 2:30.
How much time you'll take roughly?
My lord,
You take your time, that's okay.
may take time because I have to take your lordship to, one is that report, standing committee report. Then the inconsistencies in the acts. 2 acts, Karnataka Flats Act, and the judgment of the Supreme Court. And something what is being admitted by the petitioners in their petition in a detailed way, where it is each and every admissions of violations done against the RERA. It's your lordship. So it will take time.
Your lordship, 1 hour may be given to us also, association.
Now the other matter, is it separate or linked or what is?
My lord, the next one, my lord, is where the DRCS cancel the registration. This is where a cancellation has been challenged by the petitioner, the promoters. In both the cases.
Same.
Question of laws.
Then we can tag it along with this. Why he's saying separate.
No, I'm not authorized to submit.
No, we'll hear it separate. Correct, but I'm saying, in the event, this is going to spill over. Let's assume it's going to go across the roster.
Your lordship, the locus standi is the question in this particular petition, and the other one, the locus standi is not questioned.
No, that is there, but I'm saying on the legal issue, what do you say, Amicus?
Both cases, what is the correct association and who has the right to
Yes.
form the association is the issue.
Mm.
So finding in this will also have a
Affect
bearing on
the-
the other.
That is common in both.
Whether the
then-
cooperative society or the Karnataka Apartment Ownership
Correct.
Act, that is the question, your lordship.
No, then you can ask your friend, because I don't want to leave one. Now, in the event, it's going to cross over to the next roster.
Yes.
We can't leave matters where other thing is heard and conflict. I don't want to.
Absolutely.
Into much. So anyhow, you can talk to your friend.
Yes.
That order will pass before the end of the roster, whether to club or not.
Yes. But this may be
The
taken
matter
as,
for further.
this matter is already taken as parted, my lord.
No, correct, but I don't want to keep
Yes, ma'am. Absolutely.
different matter. Let it be together, either this way or that way. It cannot lead to conflicting order.
Obliged.
This is the matter at 2:30 for further hearing on 22nd.
22nd of 23rd.
Bill number?
What of, sir? 22nd of 23rd?
22nd.
46.
36. Interim order mechanism. 44 al interim order.
Just one minute. Just one minute. 44 interim order in operation is extended till the next day. 46 we'll have it on the same day. The interim order earlier than is extended till.
54 and 46 are the same.
There is already an interim order passed on 1/4. It's not till next date. List this matter on 26. You appear for the petition and that.
For the respondent,
Respond.
the fifth respondent.
That is
46.
36.
Well, it's 36 minutes. It's not a RERA project, minutes. Not a RERA project.
Independently, it can be heard.
It can be independently heard and disposed of, minutes.
RERA project ಗೆ ಅದು ಬರೋದೇ ಇಲ್ಲ. See, what type of association they should continue in future? That is the issue involved in.
Then that will.
Well, first of all, there is no association at all here. Well, that's what has happened. Some 5 persons, they are virtually taking over the entire apartment owners of 177 ownership apartments. 5 members are ruling the entire apartment owners, and whatever they're dictating, and they will have to follow their dictates. That is the problem, Malats. That's why, Malats, enquiry report has been filed, and the enquiry report nalli you will have to engage services of the administrator antantakantadu ಈಗಾಗಲೇ ಬಂದ ಆಗಿದೆ. I don't know, my learned friend has to enlighten me whether administrator has been appointed or not to the apartment, that apartment, my lads. So because, my lads, they are virtually riding on the backs of these apartment owners. Every day there is a problem. Every day there is a problem. That's why this may be taken up independently, my lords. It's not coming under RERA. It's not coming under RERA.
Independently, not same day.
Same, there is no problem, my lords. As my learned friend has submitted.
Yes. 22nd.
Obligement. Morning, my lords. Morning or?
Morning, regular.
Obligement.